fulfillment centers. And then, I mean, you work all hours of the night, and you just ship them the packages and make good money.
When I'm out of here, I'm going to home shelter.
Yeah,
Mm-hmm.
think of.
You're going where?
Home shelters. But it's cold here, it's below 20 degrees now.
Yeah. I get a coworker, he bagged ice. Like he worked at an ice bagging facility, so like, he didn't even like to touch cold drinks because from working in there, it was so cold. I was like, man, bagging ice.
Okay. I know we talked about it, but just so he's clear, so he walked. He didn't have access to a car or anything. And your girlfriend has a car, but she didn't have it then. Did you borrow your mom's car or anything? Okay. All right. And then you still had your cell phone. You had the same cell phone but you just got a new one recently when that one broke, right?
Yeah.
Okay. So that phone wasn't stolen or anything. You still had the same phone. Because it does show you walking up there between the times. Let me see. Why does this take? Everything is so slow in here right now.
Clean county.
I know.
It was all the concrete.
How have you been doing?
I've been just trying to hang in there.
But what happened? Like,
So, okay, let me say this.
I talked to your mom a little bit, and she
Yeah.
said,
Yeah, keep that over there because I don't know. They got my mom kid's house, and then we went to my girlfriend's uncle's house. Then he sold his house. Then we went to my the other uncle's house, but he got to fighting. Like my uncle, her uncle, and her got to fighting, and we got kicked out of there. And we just got a little. We staying in the hotel right now.
where y'all staying at?
Me and Black Shows.
Okay. Her baby daddy don't pay any child support or anything? Has she tried to put him on anything?
Her mom, he had all that stuff, but I don't know. He should be sending $25 here and there.
Just $25?
Yeah.
Does he see the baby?
Yeah, on FaceTime, yeah. He lives in New Jersey.
Oh.
He came like 2 weeks ago to chill with me or whatever, and that was it though. He mine,
Yeah, I see. So that's where he lives, and then you walked up to that BP station. Was it like over here somewhere where you went? I know we referenced the BP, but
Yeah. The water's doing, when I went to, wait, hold on. That's the BP. Where's the water's edge at?
you walked the water's edge.
I went through, where's the water's edge at? I went through the cut over here. It's like, you go down here, you cut through there. It's like a little cut over here. And I went to the water's edge over here, and got the weed and came all the way up.
Over where?
Like, okay, so from my neighborhood, there's a bumper road back there. It's like a bumper road. So I went through that neighborhood, and I cut through that neighborhood to get to Lakeshore. When I got to Lakeshore, I went through over there to go to Water's Edge.
Here, I'll pull it up. I would do Google Earth.
And I went to Water's Edge, and got the weed and came back up.
Okay. Because you told me it was near like the liquor store and BP gas station. I had to figure out where you live on here.
That's a computer?
Yeah. Making that noise?
Yeah.
Yeah. So that's where you live.
Okay.
So where are you trying to show me?
This is where I live. So.
I think it's touchscreen so you can move it.
Okay, you see. When I come out of here, when I go into this neighborhood, down here, I come down here, and come down here, it's like, it's a cut somewhere. It's a cut that I can get to Lakeshore. Where's QT at?
You walked to QT?
Yeah, there's a cut that you can go through to go to QT.
I don't know. You tell
The
me.
QT on Rockbridge and North Shore? Gotcha.
But
Yes, that's gonna be, yeah.
Like way up
That's
there.
like, the quick trip should be around there.
well, I went to QT and walked all the way up to Water's Edge through here.
The quick trip right here?
Yeah,
I walked like, where's QT?
QT's right there.
So
on the corner.
where's Lakeshore? This Lakeshore?
That's Woodstone.
Water's Edge,
North
that
Shore.
neighborhood across the street.
Oh, this one over here?
That's Water's Edge. I used to work down there, so I know.
That's Glen Cove. QT's right there, Publix is right there.
Okay, good. So I ran through a cut to come over here, or come over here in this area, and walked down the water's edge and got the weed.
Mm-hmm.
But,
And then you walk back?
yeah, I walked all the way back from BP to my house.
Okay.
Did you get the weed from someone in the neighborhood or someone at the BP?
What was the neighborhood?
You went to somebody's house? Yeah.
Oh, so you're plugged in the water's edge neighborhood?
Hold on.
Oh, it's kind of hard to
Well, this
is
is-
walking, you know, I can't, you know.
It's easier when you're walking to know where you're going than it is when
This
it's
is
found
how
out.
I would,
Yeah. Because it doesn't show the cuts on
Yeah.
the blurs.
Let's see.
Yeah, I worked down in that area, not the Gwinnett County side, you know, but
Yeah,
it's over
that
there.
is right there. I
Yeah.
know, yeah.
Yeah, I worked down there for years.
I mean, walk for almost 2 miles.
He used to walk everywhere. I'm from New York, man. I walk everywhere. I really
One
didn't know he
second.
wasn't this big before. I used to be skinny.
You were not big.
I mean, I'm saying now, like now, my size now, he's
Yeah.
205. So I used to be 170.
Dang. How tall are you?
How tall are you?
6'4"?
Well, about right.
Yeah.
Maybe like 5'10"-ish?
Nah,
5'11"?
nah, I'm 6
You think 6 foot?
Yeah.
6 flat? I'll give you 6 flat.
Yeah.
I want to open these things so I can show them to you. So we can just make sure we're talking about the same time because we got to bring video. I just want to make sure that's when you left. So after Tori left, you went back upstairs for a little while, right?
Yeah.
Okay. And then you only left to go get weed and then you came back and that was the time that Detective Smith told you about, right?
Mm-hmm.
You didn't leave any other time?
I did. I left to go down there and smoke with my friend. And then
Was that before or after
after she left.
after she left? And you only walked up there once? Okay. So, let me see. Why is none of this is pissing me off? I should have put all this up in the car. It was giving me issues in the car though too. That you drive is apparently empty.
That probably because we're so far away from Gwinnett.
I think it's this building. I have it in my phone now, I think. Let me look it up. It was raining that night, wasn't it? Did it not rain that night? Okay.
I think it rained that morning.
Yeah.
But that morning, I think it rained that morning. So I didn't get rid of
How you been dealing with the loss of Tori?
Not great. I don't know, it's been hard all over. It's been hard and I'll just take a day at a time, really. Sometimes you get sad, sometimes you cry and stuff, because I'll be wanting to talk to her. And it's one thing like, I used to talk to her every day, man. I used to smoke with her every day.
Yeah.
And it's hard, but you know, here I talk to my girlfriend all the time, like, when I remember something, like, you told me to do that. And,
Yeah.
like that, so it's been hard.
Yeah.
Everything been hard, man, so I just been numb to everything, man.
I know I have it in my phone from Smith, so I'll just pull it up from my text messages. Okay. So, did she tell you she left the wallet in her mailbox? She did? When did she tell you that?
When I was downstairs, when we went downstairs.
The last time before you saw her? Okay, so she told you she had left it in the mailbox? Okay, but she didn't tell you when she came at 7 o'clock that day? Did you ask her about the wallet when she came the first time?
When I seen her, I was not thinking about my wallet. I think about her because I was, looking for you, like, where you been? I'm trying to make sure you okay and stuff.
Yeah.
I didn't think about my wallet.
Okay, so this is her, and it's 10:28, so that's right before she came to your house. And here's the rings. Cross your fingers. It's gonna work. All right, I'm not even going to have that anymore, so this is getting on my nerves. Nothing's loading in here. Okay, So I'm gonna tell you what we have, and I'm not gonna bullshit you, okay? I'm gonna be completely honest with you, because there's a reason why I've been trying to push so hard to talk to you. Because, I feel like there's a lot more to the story that we're not being told, and I don't want to make assumptions, okay? And that's why I wanted to talk to you in person. I didn't want to go over the phone because, I don't feel like you'd be completely honest with me, all right? I know she had her issues. I've talked to umpteenths and lots of people about her. I've gotten her Instagram records. I've gotten her medical records. I've gotten everything. So when you say she was suicidal, I believe you. And I believe that, she did have the gun. I do believe that you guys were very close. I've read messages between you guys. I've seen tons and tons of stuff. The day she left her house was between 2 and 4 p.m. I see the messages and the contact you guys had before she left that day. I don't know what you talked about. You said you didn't really remember talking to her that morning, but it was from an iPhone.
To my dad morning.
Yeah, before she left her house. When she was telling you, like, her phone was going to be cut off for a little while. Because her mom was changing services. And you talked from a 404-559 number, I believe. It was an iPhone.
Yeah, it was with that phone.
Yeah. So you guys had conversation. Do you remember what you guys talked about?
Remember? No.
Okay.
She remember she saying that her phone would be turned off or whatever because her mom or whatever, but I don't remember anything else.
Okay. So then you told me that you went to her house like 3 times, right? And then the first time nobody answered, but you didn't see her car, right? She wasn't there. The second time you went, her dad was there. You talked to her dad. In between the second and third time, Tori came to your house, right? Okay. So that's when you guys had the conversation about the weed or whatever. And then you reached out to Jaheem. And then Jaheem took you over to Tori's house a third time. Did you talk to anybody that third time?
I don't remember. I don't remember.
Okay. So then she goes to her house at about 10:30. She gets something out of the mailbox. We believe to be your wallet. At 10:36, she's on Ring camera walking upstairs to your apartment. Then, are you left-handed or right-handed? Let's talk about that. You're right-handed? Okay. And then, she walks upstairs, 10:36, the camera cuts. Then we see you guys walking downstairs at 10:40. And then, when you get downstairs, what happens?
That's when she said she don't want to be here no more, and that's when I see the gun, and I start crying to her, and I'm trying to hug her, and she pushed me off her, and everything like that. Like, people love you. That's the whole time. I'm telling her, people love you. Don't keep this, don't do this, don't feel this way, don't, all that. And then she left.
And then, what'd you do?
That's when I went to go get the weed. I sat there for a minute, and I went to go get the weed, and came back on my friend, smoked some weed, and came back upstairs.
Austin. That's not what happened.
That is what happened.
So, you remember how I told you I got Scoop's records, I got your records, I got Jada's records, I got Tori's records, I got Jaheem's records, I got everybody's records. Tori and you walked downstairs at 10:40 p.m. You're down there for about 10-15 minutes, correct? At 11:05, you are at North Deshawn Road and Annistown Road. 11:05 p.m., you are at the corner of North Deshawn Road and Annistown Road.
Where is that? Annistown Road.
You're right there, that's Yellow River. Right after that, your phone is in Yellow River, even though you try to turn it off because it indicates that it gets turned off. You know you were there, okay? I don't want to assume what happened. That's why I'm just like, I know you cared about her. I know what she was going through, okay? What happened in the park? please be honest, because we know we have the proof now and the evidence that you were there. If it's left to us, then I don't want to make an assumption. You know what I'm saying? So that's what I'm asking. You loved her. I know you did. You're not a bad guy. You're not a murderer. Your friend didn't want to be here anymore, and you cared about her. What happened?
I didn't do anything to her.
Okay, then tell me what happened. It's okay. It's okay. I believe you, but I need you. Tell me what happened. Did you freak out?
Freak out.
Like, what happened? Tell me what happened.
I went home.
How did you get from your apartment to that location in 10 minutes? Your Gmail accounts, a lot of people don't know this. They track how quickly you're moving, and then they say what you're in. So that says you were in a car. It's physically impossible for you to have walked from your apartment to that location in that amount of time. Because I tried. I didn't want to believe like this was a situation. I tried everything. And that's why I've been trying to, you know what I mean? It's not possible. I even went out there and walked it. I tried every route. I tried everything. I'm just trying to understand, okay?
I understand.
But what happened?
Yeah, I didn't do anything to her.
I believe you, but I think you know what happened. And if we don't like hear it from you, we hear from other people, or we get all of this proof and we have everything going against what you're saying, it just looks bad. You know what I'm saying? So that's why I'm like, let's just be honest and say what happened, because I believe you. I do. I don't think you I don't think you hurt her, but you know what happened in that park because you were there. Your phone was there.
Yeah. I don't want to go to jail.
Okay.
I don't want to stay in jail.
Okay.
I don't want to go to hospital.
Okay.
It just, I didn't kill her.
Okay.
I didn't do anything. It just, after that, I know I'll be sitting in jail.
Why do you think you'd be sitting in jail if you didn't kill her?
Because she told me to, you know, take a car here, take a gun here.
That's what we need to know. You know, that's
Yeah, but-
fine. I believe you, but that's what I need to know.
And man, she shot herself.
Okay.
Man, she shot herself.
I believe you.
She never seen her talking to her, saying, please, like, I love you, I love you, I love you. And
Okay.
she shot herself, like, I did what she told me to do.
Okay. That's good. All right. You went downstairs, you got in the car with her, and then she drove to Yellow River, right? When you guys got there, walk me through what happened, because I believe you, but I just need the details to...
Sit in the car, and I'm crying. I'm crying to her, like, please don't, like, please don't. And she got in the car, we're walking, I'm trying to walk and talk to her, and she still just like, no, she don't go. Okay, so I love you. She's not crying, she's not doing anything, or nothing. So I try to take the gun from her. And she just like, you know, she's saying she wanna go. I said, no. I put the gun down, trying to hug her, and she pushed me away from her, and she grabbed the gun, and she was just
Was she standing up? Was she laying down?
she was standing up. And so I'm sitting there crying. So she told me that when she shoot herself, grab the gun, throw the gun away, and she told me to sell her car or anything like that.
Because she needed some money, right? She needed something for... Okay. All right. So where did she park in the park?
She She in park, she just pulled right up, she left her, like she just stopped right there.
Give me one, I'm gonna pull it
So
up.
I'm familiar with that park, because I used to work down there. So it was like that gravel-ish area,
Yeah.
but y'all just pull, y'all like park in a spot, you just pull up. Gotcha.
Okay, and then you guys start to walk. I'm gonna pull up the park, because Google Earth is actually working.
How many shots went off?
One.
Just one?
Here, give me 1 second.
That's why
Here you go. So, I'm getting it over so it helps you, because you've only been there a few times, right?
yeah,
All right, so this is the gravel area.
it's right there.
Okay, so she pulls up right here, and you guys get out and you start to walk?
It's right here, up here.
Okay.
And we're just talking, walking and stuff, and she's telling me, like, yeah, just take my car somewhere, take the gun, you can set it on it, whatever you need to do. I'm like, no.
And you say you take the gun from her. Were you guys standing up, walking, or had y'all sat down somewhere?
We're standing up the whole time, we didn't sit down.
Okay, so you got the gun from her.
And I was trying to hug her, but I got the gun from her time, like, don't let this night, let's go on, let's go. I put the gun down and tried to hug her, and she pushed me away from her and grabbed the gun.
Okay, and then she shoots herself. Does she fall back?
Felt that.
Okay,
When she felt the gun dropped out of her hand.
all right. And then where were you guys at? Like in,
Right there.
you know where she was found, right?
Yeah.
By the tree? So is that where she fell, or did you move her
No,
afterwards?
that's where she fell, I didn't touch her.
You didn't touch her.
All right. So,
What were her hands like? How did her hands come to rest? Do you remember?
Just out.
okay.
What about her hair? Anything stand out about her hair?
I really didn't look like I didn't look for her. I just grabbed the gun and looked.
What did you do with the gun?
Threw it in the lake.
Which lake?
The lake that's right there in North Shores. Like you go over there and just throw it.
Here.
Is it the Water's Edge Lake?
It's a lake that's like by my house. You go over there to the lake over there. And like by the North Shore right there.
So,
Not North Lake though.
No.
here you go. So this is your apartment. There's 2 bodies of water.
Here's my apartment.
Right here.
My apartment's right here.
Yeah.
So it's on the back street. It's a little lake right there.
Right here. So it's in front of your apartment, kind of?
Yeah.
So, hold on, I'm
Like,
sorry.
is it that
Is
lake?
it this one?
Where's my? No.
No, this is your building right
It's
here.
over here.
Over here? Right here?
Yeah, it's like down here somewhere. It's down here.
You can drive, you can do it.
Okay, so my apartment right here. Let's see.
Zooming in like that doesn't work.
Yeah, this is Google Earth.
It's like a little house that have a little puddle right there.
Little pond in front of it.
Yeah, you come down. Let's see. When you come down here, it's like it's a house. Okay, this is the speed bump road, right?
No.
Where's the speed bump road at? Oh, down here, this way. Okay, my apartment right here. It's one of these houses right here.
It's got a little pond in front of it.
Yeah. I don't know.
Sorry, can I see y'all, the bad pictures?
Yeah. Okay. So then, so did you do that night? Okay. So you threw it in there. What did you do with the car that night?
I'll take it to where she told me to take it.
What?
What is there? Little cut right there. She said this little
Water's Edge cut?
It's like an entrance, all the entrance that was blocked up by a little fence, a silver fence.
Yeah.
Where's Water's Edge on there? Which one is it?
Yeah, it's on Rockridge Road, right? I know what you're talking about.
How did it get burned?
I don't know, she told me to leave it there, and I left it there. So I guess she made.
That entrance right there.
Oh, right here?
Yeah. That little entrance that's
Yeah,
on.
the old entrance.
Yeah, it's got the chain link fence blocked up. Yeah. So-
Okay. Oh, I know what you're talking about now. So you left the car there, and then, so did you leave the car, did you go dump the gun first and then go take the car?
Yeah, I dumped the gun first, and then left the car.
Okay.
But, see, that's why I didn't assume, because I know, like, that could put me in jail just for being here and just taking the gun in the car and stuff. I just,
But does it feel better telling the truth though?
it
But
doesn't
that's what we
feel
want. We want the truth to be able to tell Tori's family what happened and give them some peace. And it's also gonna make you a big weight off your shoulders.
Did you touch her at all afterwards?
after.
Yeah.
Um,
There was just some,
I didn't want to.
so you just picked the gun up and then you left?
I was crying. I was just, yeah.
So how far away do you remember was the gun? Like from her?
When she picked it up and
Before
before
she
she
shot
shot herself?
To be honest, it happened so fast. I don't remember, to be honest. I just heard a shot. And to be honest, I heard a shot and then I blanked out. Like, it felt like my soul went out my body. Like, with her, like, it just, and I was just standing there and then she fell.
Okay.
I was standing there crying. I picked up the gun and just didn't know, I just did what she told me to do.
Mm-hmm. So did you guys talk about it on the way there?
I kept telling her, like, no, just please take it on. No, like,
Okay. I'm so sorry.
I,
I know, it feels better probably now, doesn't it?
yes, but at the same time,
Jada's mom kind of dropped it a little bit. She said she killed herself, didn't she? And I was like, how? Nobody said that. So like, how do you?
because I told her, because Jen's mom told her, like, she told me she wanted to kill herself. And somebody got kept saying somebody killed her or whatever. So like, mentally, she killed herself. She had somebody kill her or something. But so I said,
Yeah.
but
Did you talk to Jayla about it at all? Okay. How does it?
it's weird.
That's probably what's been.
Making us, yeah. But I never wanted this. I never wanted this to happen. I don't want this to be true. I still want my friend to be here.
Mhm.
And
Who did you talk to that night afterwards?
talk to.
Yeah. So while you were doing all of that on your way back, you were talking to somebody. You tried to call somebody on Instagram, and you were talking to a phone number. I think his Instagram, it used to be One Luski. Yeah. And you were literally on Rock Ridge when you called him. So.
I probably need some weed or something. I need some weed because I'm marking weed. I have dirt, so I was more trying to get some weed.
So you went to buy weed after that? Okay.
I did get some weed that night.
Okay.
Yeah.
Where did your clothes go that you were wearing that night?
It's in the house. We went in the house and it's gone now. I was in a store somewhere or something like that.
How close were you to her when she shot herself?
I was standing right here, so she's about like, where you at?
Did any blood get on you? No? Okay. And you said you didn't manipulate her body at all? You didn't touch
I didn't
her?
touch her at all.
Okay. All right. You just picked up the gun, because it had fallen next to her, right?
But I'm saying, like, multiple times I have tried to hug her. Multiple times
Yeah,
I
yeah,
tried
yeah.
to hug her. So,
But after she was dead, you didn't? Okay.
because the scene is
How did she fall? Was it like straight back? Did she like?
I blanked out, man. When I heard it, like, I just seen her fall. She just fell.
Mm-hmm.
You know, I just seen the gun fall, so she just fell. Like,
Okay. All right. I really want to see that water though. I believe you.
but I don't want. I really just never wanted this to be true. I want my friends to still be here, and I didn't know what happened to me. You know, I want to be here for my family and my son. Like, baby, I just want to be here still so I can still raise my son.
Yeah.
I don't want to be locked up. I don't want to be somewhere for a long time with murderers. And I'm not that. Like, I'm not.
Right.
were 2 shell casings there. So the gun was fired twice.
One shot. One shot. Only one shot.
Okay.
Not for sure, God.
This is not gonna work.
I mean, y'all, I know she only shot herself once, but like, did the gun ever go off while y'all were tussling over it? No.
Did you set it on the ground, or did you set it on something?
I jumped it on the floor. Jumped it on the floor.
Because I mean, the technology now that we can compare the shell casings, and then we know they came from the same gun. That's what we're just trying to figure out where the second one came from.
Well, she did tell me earlier she been had the gun all day. Like she been trying to do it all day. Like so, she had it placed in or whatever. But
Yeah.
it was only one shot. One shot.
Okay.
And when it failed, I grabbed it and left.
How did you get back from after you dropped her car off? You did it that night, right?
I walked back. That's when y'all see me on the BP. I walked straight home.
Okay. I'm just trying
So
to.
what time was this about? When all this happened? Was it like right after the last time she came over, and that's when y'all left her?
Right. That's what I never understand. I don't want to be in jail. I know I didn't do anything. It's just, I know taking a gun and taking a car is bad. I could just call the police and just, yeah, but I don't want to be in jail.
Why did you turn your phone off
Because I was scared.
when you went into Yellow River? Because you turned it off. I think you sent Jayla a text message, right? What did you say in that text message?
I think that everything's okay or something like I'm coming home or something like that.
Okay. So then you turn it off, and then you turn it back on once you're dropping everything. Okay. How long were you guys in the park before she shot herself?
About 10 minutes or so.
Okay.
I don't know.
Okay, so here you go. Here is the BP. I'm trying to find that house with the lake, with the water.
Where's
The BP is right here. This is Rock Ridge.
BP.
But it was on,
Okay, so my house.
it was on his street.
Oh, it's on your street?
Yeah.
Okay. Oh, yeah, because you put the car here.
Yeah.
Okay.
My street is a speed bump road, and then like a little house with a little black fence, and so like what's it called when you fish off of it? And it's like
The dock, like a little, yeah.
and it's a pond. Go right in there.
Okay, so here's your house. This is like your legit building.
Okay, this way going down this way is the speed bump road, right?
No, that's 124.
Oh, wait.
This
Down
is
this-
speed bump road.
Okay, speed bump road. And I guess this house right here, I think.
This house?
Yeah, I think it's right
I
there.
can get closer.
Yeah,
So like through those trees, there's a little pond.
yeah.
Let me hover, change the view. I don't know if it's gonna get any clearer.
I think it's gonna get.
This damn thing.
Yeah, but it's
It's right there.
Yeah, it's the only pond that's on that street though.
Okay. Is it deep or is it?
I don't know. I know it's green. So
Okay.
I'm saying, like, am I gonna go to jail for that? For taking my car and all that?
I mean,
That's a year.
it's technically illegal, but I mean, I don't know, man. I gotta figure everything out because there's still some, like, a few unknowns because I just have to look at everything again. But I will let you know, okay? Tonight, nothing is happening. We'll still talk. Just stay in contact with me. What is your deal with getting out here?
I got to pay a bond, and I got to go to Sandy Springs, and I was going to finish the bond.
How much is your bond here? It's $1,000. Is she gonna get you out?
You get somebody else to give me now.
Okay.
You gonna pay it tomorrow.
Okay.
You should only pay like, what, 10-15% of that? So like a couple $100.
No, my bond is 10,000.
Oh, 10,000, oh, okay, so 1,000 will get you, gotcha. I thought you meant just 1,000. I was gonna say,
So, I mean, you know, it's out and everything like that, so I know I'm gonna have to do something like, I'm gonna have to sit down for a certain amount of time on it.
And so you gotta, I'm just thinking, so you got that, and they're gonna come get you tomorrow?
No, they're paying my bond.
Yeah, and then Sandy Springs will come get you, but that's,
I'm talking about,
that's a ticket,
I'm
yeah.
talking about this right here, yeah.
Oh, I don't have an answer for you right now, because I gotta go back and look at everything.
So for clarification, can you just give me my bond?
Yeah, so I mean, what you did technically, yes, tampering with evidence, but I mean, we also need to speak with our district attorney's office to see, just because of how this case is, you know, not that they won't prosecute, they might not want to, they might want to, you know, it could be, it's not solely up to us. So all we do is we're fact finders. We try to find the truth, we report it, we write a report, and we send it to the district attorney's office. And at the end of the day, the decision is what they want to do. But I mean, you know, I know this stuff, it's been a while trying to get a hold of you, but now that we've sat down and talked to you, I know I had to step out a little bit, but you know, you've been very honest with Detective Carter, you've been honest with me. You know, I think, you know, hopefully that will show and go a long way.
Yeah, definitely. Okay. So, anything else you can think of that, did you talk to anybody about this? Did she say that she talked to anybody else to help me corroborate your story?
What's his name that got locked up? Said he's Tori Lang, said you go talk to him.
Marquez's baby daddy?
She said, like, only thing she told me is that she asked people to do it. She told me over time, she always asked people to do it. So I don't know if she taught anybody to have plans or anything like that or like that, but
She didn't tell you in particular who she talked to or asked to do it?
she only told me, she asked people to do it. That's the only thing she told me.
What did you tell Scoop happened?
School, I don't know, but.
Okay.
But,
She's so upset that he did this. I was like, I don't know, he didn't do it.
but,
Yeah. Have you talked to Draco at all?
Draco, no, he ain't talking.
Okay.
But,
Anybody else?
not talking about it.
And you said you don't know anything about the car.
He came to my house when it burned. He came straight to my house.
Who did?
The detective before you came.
Smith came to your house
As
after?
soon as he
Okay.
got the car, he came straight to my house.
Okay.
And I told him, I don't know.
Okay.
I just want to be here for my son.
I understand. So you guys were in the car. What made you get in the car?
I mean, I was trying to keep talking to her until I'm not doing it, talking her not doing it. And I'm trying to show her that I'm distraught. I was crying like, she was acting really weird. Like, she was not crying. She was not trying to look at me or anything. I'm trying to tell her, like, I love you, people love you. Like, something, it was weird. Something was weird about it. Like, I could see her dark. Something was wrong with her. And you just couldn't say today's my day. Like, she went go.
And then she said, I'm gonna shoot myself.
She ain't never said. She said, I want to go, I want to go, I want you to do it. And I said, I cannot do that. I can't do that for you. I can't do
So
that.
she said, how did the conversation go where she told you what to do with the gun in the car?
She said that after, like, what happens, take the gun, sell it or whatever, do whatever you need to do with it, and the car, sell it, do whatever you need to do with it.
She told you to sell it? But I thought she told you to put it in that cut.
No, she didn't. I didn't say she didn't sell it, but she said, always sell it, do whatever you need to do with it.
Oh, okay. I thought you said she told you to put it there. So you
She
just,
told me to put the car in that cut.
to sell it?
No, she said, told you to put the car in the cut. You can sell it. She told me to take it there. But she said, you can sell it, do whatever you want to do with it. But you can take it there.
Okay.
But,
So did you get your wallet actually that day?
yeah.
Okay.
Maybe she left it right there in the car.
And so she was where she was at, under that tree. You guys were standing under the tree. Was it dark, light?
It was dark.
Could you see each other?
A little bit from the moonlight. That's it.
Okay. And then you get the gun away from her. What is she saying when you're trying to hug her?
Stop touching me. She said, don't touch me. Stop touching me.
And then you put the gun, oh, the gun's
Well,
on the
The
ground.
gun's on the ground, man, I'm trying to help her, and when she pushed me over, she grabs the gun.
And she stands all the way up. Was it instant, like she grabs it? Can you just motion it for me so I can understand? I'm sorry.
So you're me, right?
Yeah.
So I'm trying to hug her and stuff, and then like she puts off me and she grabs the gun.
She scoops down and and then what?
She grabs the gun and then
Pop, and then she just goes straight back? Okay. Where was the gun at?
It was like what's it called? 5 rails on the tree.
So did it fall by her feet?
It fell out of her hand. It fell like she saw it. It fell out of her hand. So
Okay.
It was above her.
Okay, so when she fell back, Okay.
It was above her. And,
did she move or do anything afterwards? Some people don't die instantly, so
did she move? I don't know. I was there.
did she make any noises?
I was just over there crying. I was crying loud. I was crying. And I was grabbing the gun and left.
Was it instantly you grabbed the gun and you left?
It wasn't instantly. She shot herself, and I'm sitting there crying. I'm crying. Oh my God, I really wasn't even. I was running like running in a circle.
Yeah.
And oh my God, and I heard her. I don't know, but I heard a little like I heard it, and I grabbed the gun and left.
Okay.
And I know I should have just stayed there, called the police and everything, but it's a body from me. I don't know what to do. I'm black. I'm tall. It's terrifying. She's light skinned, and I know how the world is. I just know how the world is, and I just did what she told me to do, and that was where I messed up at.
Okay. I'm trying to, and I'm only asking, if I come off harsh, I'm not trying to be harsh. I'm trying to get the answers that I need to be able to answer for you later. Does that make sense? So, you turned your phone off because you said you were scared.
Yeah, I turned it off. I didn't know what was going on. I just turned it off.
Mm-hmm. What were you scared of?
So I was just anything. I just turned it off.
Because this was before she died, right?
Before she died?
Yeah, you turned it off before you got to the park.
My phone. It was an iPhone.
It was the one you had your Gmail on. You turned it off after you texted Jayla at 11:05 and told her you guys were good. And you turned it off because then Jayla tried to call you multiple times and you didn't answer.
I just turned it off. I just turned it off. I was paranoid. I just scared. I just don't know. Just turned it off.
Okay, because that is a little weird, I'm not gonna lie. That is a little weird, like I don't understand what you were scared of. You get what I'm saying?
Yeah, I understand.
If she, you know what I'm saying, if you had an agreement that this was gonna happen, I can understand that maybe. Like you had an agreement this was gonna go happen, you didn't really want to, but you were probably gonna help your friend out because you cared about her, and you knew that this was about to go down and you guys had planned it. And you knew you knew it was going to happen, so you turned your phone off before to try to disconnect yourself from it. That would make sense, but if she was talking about killing herself, like, how did you know at that point to turn it off because you hadn't made it to the park yet? Did she tell you where you were going?
We just drove around.
So at 11:05, when you're at that corner, right before you're about to get to Yellow River, that's when you decide to turn it off because you hadn't gotten there yet.
Man, I just turned it off.
I mean, I'm right. It was before you got into the park, right?
I guess I just turned it off.
Okay. I mean, you get where I'm coming from, right? That's why I'm trying to understand it so I can later articulate it.
Okay, so I don't know. I just turned it off.
Okay.
That's what I'm trying to remember which phone I had because my Android I had to turn it off a couple times because it messed up a little bit and stuff like that. But
Yeah.
I'm trying to remember what he sent my Gmail. It's been some time. I don't remember.
Okay. So it was your Android because you text from the 865 number. and you were texting Jayla. I keep saying Jada, it's Jayla. You've been locked up since the Oscars, so that's why Jada's fresh in my mind. You know Will Smith slapped the shit out of Chris Rock? Yeah. So that's something in Jada. And like I said, I'm not accusing you. I'm trying to understand because these are going to come up later, and it might come up later for you too, so I just want you to understand. That's usually what, him and I've been doing this a while. We haven't always been in homicide. We've worked in I've worked in robbery, special victims. He's worked in burglary, robbery, plus we've been on the road, and so we've investigated a lot of crimes. And usually what people do is they turn their phones off before they get to what's about to happen, so they can't be tracked because they know a crime is about to happen. Does that make sense? So that's what it's going to be perceived as, and I don't want to do that if that's not the case. I'm trying to fully understand where you're coming from on that. And do you have another way to word it, maybe?
So you're saying I'll turn my phone on?
Before you got to the park, yeah.
Before I got to the park?
In our experiences, say the three of us are gonna do like some armed robberies or something like that, a lot of times people will be like, all right, well, we're all gonna turn our phones off so nobody knows where we're going before we do something. So was she like, hey, let's turn our phones off and go, walk?
I don't want to say she told me to turn my phone off, because I don't remember.
Okay.
Because I want to just say. So I was paranoid. It's been a minute. I don't remember.
Okay.
When I turned my phone off.
Yeah.
I don't. So she could have told me to turn my phone off. I don't know. I just turned my phone off. I know I was paranoid. So I turned my phone off.
Okay.
So I don't want to just say she told me to turn my phone off, because I'm not 100%
Right.
sure.
Yeah. Okay.
And she, like, we on the road, like, on the way there, she was telling me everything, like everything, so I don't know.
Why didn't you call the police on the way there? I'm asking because this is going to come up later. I'm just asking. People are going to ask me, so.
I don't know, because you can really know that story, she don't never go through with it, I thought,
She just talks about doing it all the time.
yeah, and this time, man, things are going to be like this.
Okay.
I don't want to be in trouble. I want to raise my son. That's all I want to do. I just want to raise my son.
Another question, just to say we asked it, did you shoot her? Okay.
Why wouldn't you shoot her if she wanted to die?
Because I want to raise my son, and that's murder. That is murder if I shoot her. I want to be here for my, I want to be here for jail.
No, I believe you. I just wanted to ask why, because it'll come up later. Nothing's working. I give up.
I'm sorry that I gotta do all this, but the point, I just want to raise my son. All I want to do is raise my son. I don't want to be a statistic and be in and out of jail.
Yeah.
Because I know me, my dad was not here for me.
Yeah.
And I grew up to a certain way because my dad was not here for me. I don't want that for him. I want to be here for him. I want to raise him right. I want to make sure he's a good man, better than me. Make sure he don't do stupid things like not do the right thing. Like me, I messed up. I should have called the police.
Yeah.
But seeing her right there and all that, and I didn't know what to do. I didn't know what to do. She told me, go ahead, just go take the car. So that's all I played in my mind. Take the car, take the gun, go ahead, go.
Did she still want you to shoot her when you guys were in the park? Was she still asking you to do it? Okay.
I didn't want to take the gun. I didn't want to touch the gun. I didn't think, but I just took the gun from her, and I was telling her, just calm down, and I love you, and I dropped a bunch of I love her, and she put her up there and grabbed the gun and shot her.
Okay.
And I know I'm a black man.
That means nothing to me. I just want to let you know. I want to let you know that means nothing to me.
Y'all, but
I get
one
it.
of them juries and all that, it's like, it's the world. I don't even know. So,
Do you have any questions? Okay.
And before we head out, is there anything else that you think we need to know?
Anything you can think of that might help me corroborate this? Because I want to corroborate it. Do you know what corroborate means? I want to find evidence to prove your story.
that's know, she was saying.
You told her she was suicidal?
I didn't tell nobody anything. I was like, nobody anything. So, I just pray and hope that I don't have to, like, I know what I would do, like 30 days or whatever. I'll do whatever I do, but I don't want to be gone for 5, 10 years.
Yeah.
I want to, because I want to raise my son. I don't want to be in where the murderers or rapists. That's not me.
Yeah.
That's not me at all.
I know.
And I pray every day and just like tell God, I wish I did the right thing and just call the police. I wish I did the right thing and just, like, when I had to come up and just shot all the bullets out.
Yeah.
Like, I wish a lot of things. I pray for a lot of things that y'all can really help me though.
I'm gonna try.
I mean, all we can do is take what you said and put it in a report.
So how it works, we're like fact finders. So when I say I'm gonna try, it means I'm gonna try to go find evidence to back your story. Because I wanna look into it. Because my job, I don't want, if someone's not guilty, I don't wanna lock them up. My idea is just to get all of the evidence and put it together.
Like, we're gonna go out, we're gonna try to find this lake, we got dive teams, we're gonna go dive in the water and, hope we find the gun that you said is there.
What else? Like,
I can't think of anything else right now, but are you open to talking to me again if I come? Okay.
Just call me and everything, but I mean, like one time I have to go to work, I have to
I know.
provide and everything.
But now can you stop avoiding me? I'll come meet you. I'll come meet you. I'll come meet you in the parking lot. I don't think they're gonna let me take it. He has my number.
I was just,
All right.
But it's just,
I'll come meet you on your lunch break. Whatever. I have a car. The county pays for it. Not your tax dollars because you live in a cab, but the Gwinnett County residents pay for me to go wherever I need to go.
please, just keep that in your mind. I just want to raise my son and be the best man I can for jail.
I understand.
I understand I'm mad for taking the car and all that stuff and all that, but that's honestly God's truth.
If you could talk to Tori's mom right now, what would you say?
I'm sorry that I didn't tell you earlier. I'm sorry that I should have told you that, something happened to her. I'm sorry. And to be honest, Tori talks to me. Like she talks to me. She always talks to me. And the biggest issue was her mom. The biggest issue was like she felt more depressed because of her mom. And I mean, I can't say nothing to her mom. Like, 'cause I feel the same way Tori feels towards her mom. So, that's all I say to her is sorry. And I wish she could understand her daughter more. Like, she could understand her more. She probably would have been here. But that's it, really.
Okay.
Please just have that in your mind. I just want to raise my son and be the best man I can. I'm not a murderer. I don't,
I'm curious I was asking you because, I have to go back and talk to her mom. I talk to her almost every single day. And it's been 8 months, and she's been going through it. Granted, her and Tori might not have gotten along, but, you love your son. I love my son. I'm a parent too. Even if we don't get along, you still have this love. Like, it's a piece of her. So she's been going through it.
I wish you could understand Tori more. That's the biggest thing is money. And her mom, Tori didn't live with her mom one time. Her mom, Tori was doing better at her own grandmother's house than she was at her mom's house. And when she forced her to come back to her mom's house, that's when everything was left. But I want to raise my son. That's all I want to do is raise my son and be the man I can be for jail, and get us a big house and everything like that, and go to the NFL and do everything I want to do, but I don't know. I told you this honestly. I told you everything.
Okay.
And so this case right here, from a jury standpoint, what would happen?
Oh, it's a long process after this. It's not, there's just so much that goes into it. I can't answer that. So for me, I'm gonna type everything up. I have to go meet with our district attorney, our district attorney's office, and then our liaison that works with us, and then go over everything as well as talk to my sergeant about things. That's why I said I can't give you an answer now. So based on those conversations, either charges will be taken or they won't be taken. If charges are taken, then, warrants will be placed for your arrest. You'll come to Gwinnett County Jail. You'll be appointed an attorney. Then you'll start the process from there. So I don't know what charges, like I said, because I don't know what's going to happen.
Gwinnett County Jail, was that White Street?
It's a lot nicer than this one.
Yeah, there's
White Street?
No, Gwinnett.
No,
Around 360.
you said where's it at?
No, I'm saying White Street, like that's White Street?
No.
Oh, because I'm hearing Sandy Springs don't have a jail.
Yeah, you gotta go Fulton County.
Fulton County is what?
I think isn't it DeKalb? Oh, I thought it was DeKalb or something. So DeKalb jail is not nice. Everyone, like, when I've arrested people before, when I tell them we're going to Gwinnett, they're like, hell yeah, as long as I don't go to DeKalb.
Yeah, they say Gwinnett's like.
Stopping at 1 hour, 10 minutes, 45 seconds. Detective Carter, you are, at this point, the lead detective on this case, correct?
I am.
Is your role to know each and every part of the case, including what was done by Sergeant Smith, other officers, the medical examiner, everybody and everything in the case?
It is.
Did you end your investigation right here at this point where you've gotten some admissions from the defendant?
I did not.
What did you continue doing after this interview?
I went back to review the evidence again and compare it to statements that he provided in his interview regards to her shooting herself, the way he explained it, and falling down. The way she was located didn't make sense based on statements he made. Excuse me. Well, in my head, it didn't make any sense because of the way she was located. Her braids, I believe, were 36 inches long, and none of them were underneath her. If somebody falls, the way he described it, the hair is going to be, there's at least going to be some hair under her. It's not going to be like perfectly sprawled out behind her head. So it made sense in my head, but I wanted to just verify, so I did purchase a wig that had similar length braids, put it on one of the dummies, and we dropped it like a million times, and again, nothing similar to the scene where we found came out from that.
Is the way Tori's hair was laid out when she was found consistent with the lady with long hair throwing her hair back before she lays down?
Yes.
When you interview a defendant, do you always tell him the truth?
No.
Do you use various and sundry interview techniques to get him to continue talking?
Repeat your question, Mr. Norris Lewis.
Do you use various and sundry interview techniques to get a defendant to continue talking?
I overrule the objection. I will allow it.
Yes.
Does that include agreeing with him?
Yes.
Does that include telling him you believe him?
Yes.
Can it include outright lying to him?
Yes.
After you determined that his version of events simply did not make sense and did not comport with the evidence, what was your next step?
I met with assistant district attorneys with our district attorney's office and presented the facts of the case to them because of the way the case was going. The way the medical examiner ruled her death, I wanted to put everything in front of them, explain the facts, explain the inconsistencies, and get their opinion on where they wanted me to go with this.
Ultimately, did you take warrants against the defendant?
I did.
What charges did you take warrants for?
Aggravated assault and felony murder.
And being the lead detective and knowing everything about the case, did you know anything about the vehicle that Tori had?
I know that it was burned in Hidden Acres.
You know what kind of vehicle it was?
Yes, it was a 2012 light blue Nissan Versa.
Were you able to determine its approximate fair market value?
I looked it up on Kelley Blue Book, yes.
About what was that fair market value?
It was for a used vehicle that year. The range was $5,009 to $6,794.
Sorry, 5,009 to what?
$5,009 to $6,794.
Did you investigate the pond, lake, or body of water where the defendant told you that he had thrown the gun?
We did. Hall County dive team came out and assisted us with that, and they did dive, but they did not locate the firearm.
Now, at this point, we are in March of 2022, is that correct?
It was the end of March, I believe. I'm not sure if it was right into April yet.
And how many months after Tori was killed did we discover where to even look for the gun?
8, 9 months.
That's all the questions I have at this time.
Right, cross-examination. Sure. All right, ladies and gentlemen, we'll just use this as our mid-morning break. So we will be in recess until 10:45, and then we will go until the lunch hour. Please leave your notepads and pens in your chair. Remember your precautionary instructions. And step down.
Thank you.
10:45, please. All right, Mr. Ford is back with the deputies, 10:45.
So that case downtown, with the multi-co-defendants, the 9 months, Bruce Harvey and a couple of the other defense attorneys.
All right, is the state ready for the jury?
Yes, sir.
Defense?
Thank you, Judge.
All right, let's bring in the jury. All right, cross-examination by the defense, please.
Thank you very much, Judge. Good morning, Detective Carter.
Good morning, Mr. Lewis.
How are you?
I'm good. How are you?
Good, good. I'm doing well. Let me start here with Tori's social media. Did you check on Tori Lang's social media?
On her Instagram and her Facebook.
Okay, and so that answers two other questions. She was active on Facebook and Instagram, is that right?
She had a Facebook account, but she did not appear to be active in it. She didn't appear to be actively using it, but she was using her Instagram account.
All right, and did you use her Instagram account to find out if she had any friends that might have any information concerning her death?
I did.
Were you able to get any names of any friends or interview anybody that she had been in contact with on Instagram?
I interviewed multiple people.
Did you interview Scoop?
No, he would never call me back.
Okay, he was active on Instagram, but you never interviewed Scoop, is that right?
That's correct.
All right. And what was his relationship to Tori Lang?
They were in a relationship, but he appeared to be involved with other individuals.
All right. Did you ever have any chance to speak to Marquasia Watson?
Yes.
What was her relationship to Tori Lang?
They were friends.
Do you recall how long they had been friends?
Years.
Were they friends both in real life and online?
Yes. Did you say Marquesa or Marquesa?
Is it Mark? I'm sure.
So there's a Quasia and a Marquesa, so I'm just making sure.
So we go with the surname Ms. Watson. Is that Marquasia Watson?
I thought it was Marquesa Brown, but I could be wrong.
Okay.
Yeah.
Okay, give me the two names. You think there's a Marquesa?
Yes.
Okay. And you think her last name is what?
I believe it's Brown.
Okay. And you had a chance to speak to her, is that right?
Multiple times, yes, sir.
She was a friend of Tori Lang's?
She was.
I may have the name wrong. Sometimes that happens. And they have been lifelong friends, is that right?
Yes.
And who's the other person you were thinking?
Quasia.
Quasia. And what's Quasia's last name?
I can't recall it this time, but it might be Watson. I just know when I tried to run the last name she gave me, I never could get a return.
Okay. And what was Quasia's relationship to Tori Lang?
They were also friends.
Also friends. The same length of time that Marquasia Brown was friends with her?
No.
I'm assuming that sometime you spoke to Dr. Terry, is that right?
I did.
Do you recall when that happened?
It was shortly after I took over the case because I had additional questions.
Okay, and my understanding is the other detective was on the case for about 6 weeks, is that right?
Yes, sir.
So somewhere around maybe the first week or second week in September, you took over the case, is that right?
It was whenever September 19th. It was that week of September 19th, 2021.
That's fine, September 19th, 2021. You took over the case, and if I understood your answer correctly, shortly after that, you went and you spoke to Dr. Terry?
Yes, sir.
Did you review the medical reports before that time, or did you go speak to her first?
I reviewed the medical reports beforehand.
All right, then you go over and you talk to Dr. Terry, is that right?
Yes, sir.
Okay, and obviously the goal after you read the report, when you go talk to Dr. Terry, is to try to get some clarification on her thoughts, Dr. Terry's thoughts about whether this is a suicide, homicide, or closer to a suicide versus a homicide. Is that fair to say?
Yes, sir.
All right. You indicated to the jury a little bit ago that you videotaped some physical demonstrations after you bought a sort of mock dummy with long hair and dropped it in numerous different directions. Is that fair to say?
Yes, sir.
You were trying to determine how Tori may have fallen after she was shot. Is that correct?
Yes, sir.
And in fact, you also went out to Yellow River Park and dressed up in a certain way to try to see how Tori may have fallen after she was shot. Is that fair to say?
I don't believe we did falling because I didn't want to fall to the ground. Okay. But we did see if dragging and stuff like that. Okay.
And all of this was recorded. You're being on the scene where Tori was found and you dropping the doll, the life-size doll with the hair, all of this was recorded, is that right?
It was. The dropping of the doll was actually at our training center because it was the training dummy that they used.
Right.
They used, sorry.
Right. No, it's no problem. And all of that, if I understand you correctly, was done after you spoke to Austin on March 30th, 2022, is that right?
Yes, sir.
Okay, and Dr. Terry has come into court and testified that Tori was indisputably laying down with her facing up. Were you left with that impression? Were you left with the impression after talking to Dr. Terry that Dr. Terry's position was uncontested? Tori was laying on her back with her face towards the sky. Were you left with that impression in September of 2021?
After I met with her, I was not left with that impression. I believed, she said, it was consistent with her being laying on the ground. At that time, everything was still new and it was still fresh. So I don't believe I asked any further questions like, is it possible she was standing? Is it possible this? Is it possible that? My questions with Dr. Terry when we were meeting were more or less in regards to the radius of the gunshot wound or the distance of the gunshot wound, questions about the possibility of it being like that, and I did ask her if she did fall, like, would there be blunt force trauma to her head? Like, would there have been injuries to her head? Stuff of that nature, just basically trying to get a better understanding of things.
And I love that last question, because that, of course, as an investigator, made sense to you. If somebody shot and they fell backwards, when they hit the ground, there would have been some type of blunt force trauma to the head or back. Is that fair to say?
Yes, sir.
That's sort of your experience as a homicide detective, is that right?
You would think so, yes.
Sure. And when you put that question to Dr. Terry that way, hey, you know, if a person was shot and they fell backwards and they hit their head with their experienced blunt force trauma, did Dr. Terry say, listen, you don't need to worry about that, because I'm telling you, the science says she was laying on her back with her face towards the sky. Did Dr. Terry tell you that?
No, she just answered my question directly and said that if someone falls to the ground, there's not necessarily a sign of blunt force trauma.
I like when you say answer your question directly, because the jury's already seen Dr. Terry correct my grammar twice. So we know Dr. Terry's not the type of person that you're going to just bully around. If you say something crazy, she's going to turn right back around and tell you, you don't need to worry about that, because this is how the body was. You don't find her, you don't find that she's the type of person that you can bully, do you? You being the detective, if you have a theory of the case and she has a theory of the case.
I'm going to object and ask that Mr. Lewis either ask a question or allow Detective Carney to answer the question that he did ask.
That's right. That's
Right,
right.
so that's
My
sustained. This isn't your closing argument, Mr. Lawrence Lewis, so please ask a question while the witness is on the stand. Sustained.
Yes, Judge. You don't find that Dr. Terry, and you're dealing with Dr. Terry, is the type of person, if you have a different theory than her theory, that you can just bully her into your theory. You don't, that's not your
Absolutely
person.
not.
Right. So when you put to Dr. Terry, hey, if a person is shot, falls backwards, would they have some blunt force trauma to the head? She never told you at that time. You don't have to worry about that, because I'm telling you, the science says she was laid out flat when she was shot in the head. She never told you that, did she?
No, I think she was just answering my question.
You requested info on Austin's cell phone after you were assigned on the case, is that right?
Yes, sir.
Okay. If I understood your testimony correctly yesterday, the cell tower triangulation showed that Austin was at his apartment for most of the time between 10 p.m. and 6 a.m. Is that correct? Do I have that right?
Some of the times in between there.
Okay. Did any cell tower ever put Austin inside of Yellow River Park?
No.
Okay. And I thought that you testified that Google put Austin somewhere on Annistown Road about 11:05 p.m. Do you recall testifying to that yesterday?
Yes, sir.
Okay. Where did Google put Austin on Annistown Road at 11:05 p.m.? Annistown and what?
North Deshaun Road. It was at right at the corner.
Okay, good. There's a little gas station there.
Yes, sir.
Okay, I got you. Okay. And did Google tell you where Austin stopped when he stopped moving quickly, which led you to believe that he might be in the car? Did Google tell you where Austin stopped?
He ultimately went back to his apartment.
Okay, and so is that where Google told you that he stopped?
So it did continue showing movement. So he was at his apartment after the vehicle, and then you can see him leaving afterwards. And then it continued to move after that.
Were you left with the impression that the vehicle stopped at any particular place by following the Google information on Austin's phone?
It appeared to be in the area of his apartment.
Okay, and his apartment is located on 124, is that right?
Off of one, yes, sir.
Off of 124, just across the street. I think the church down there is, what's the name of the church down there?
I'm not sure.
I have it somewhere, but that's fine. We'll get back to that. 124 just south of Rockbridge Road, is that right?
Yes, sir.
Okay. Stronghold Christian Church. Do you recall seeing the large church down there, Stronghold Christian Church, across from Austin Ford's apartment complex?
There were buildings around. I didn't take notes of them or anything.
It's fair to say you can see Austin Ford's apartment complex as you travel south on 124. Is that fair to say?
Yes, sir.
Okay. And I think your testimony yesterday was Google gives you more accurate information than the tower triangulation. Is that fair to say?
Yes, sir.
Okay, and that's why you requested the geofence at Yellow River Park?
I requested the geofence at Yellow River Park prior to thinking of Austin as a suspect. That was an attempt to figure out who may have been there or other witnesses that may have been there.
All right. Did the data give you any devices inside that geofence at Yellow River Park?
No, they were just traveling on Juhan Road, passing the park.
Okay, and when you say they, you mean the cell data that you received, is that right?
The geofence data.
Got you. Tori's cell phone, where was Tori's cell phone at midnight from the 27th into the 28th of July, 2021? Where was her cell phone?
It was with her mother, Teresa Lang.
Okay, and did you ever find out if that was sort of normal, that Tori would just sort of leave her phone like that?
I don't believe it was normal, but the reason was they were, I believe, transferring services. They were going, I believe, from Verizon to Xfinity, I think.
Okay. So Tori's cell phone, was it on the entire time?
But yes, it was.
So it was on, but she had left it behind with her mother, is that right?
Do you mean turned on or service active on?
I'm just,
I apologize. I'm just trying to make sure I'm right.
it's no problem. I'm trying to figure out how anybody in 2021 leaves their house without their cell phone.
Yeah.
But I understand your testimony to be Tori left her home without her cell phone because something was going on with her cell phone. Is that right?
Yes, sir.
Okay, that's what I want to understand. When was the last time Tori appeared to have used her cell phone?
That morning.
Was she making calls?
She received a call from a phone number registered to Jayla Summers.
Okay, do you know to whom Tori made her last call?
She didn't make a call. She received a call and answered it.
Okay, do you recall if you can recall, do you know who Tori's last text was?
No.
Do you know if the texting and the call that she received were about the same time?
Yes, sir.
The first time you spoke to Austin on the phone, was that August 25th, 2021?
No, I didn't have the case yet. Are you referring to October 25th?
Yes, that's what I have here, October 25th.
Oh, I thought you said August. I apologize.
No, that's me. I asked, August 25th, 2021. You didn't have the case yet.
No, sir.
When was the first time you spoke to Austin on the phone?
October 25th, 2021.
October 25th. So the conversation that we listened to yesterday where Austin talked to you a little over an hour, that occurred on October 25th, 2021. Is that right?
Yes, sir.
Okay. In that conversation, which we listened to yesterday, Austin indicated that he thought Scoop was a bad influence on Tori.
Yes, sir.
You heard Austin say something about perks, beans, and Xanax, right? That you heard Austin say that. Is that right?
Yes, sir.
Okay, I don't know if the jury knows. Perks is Percocet. Is that right?
Yes, sir.
Okay, and beans is ecstasy.
Yes, sir.
Okay, I got that right. And Xanax is Xanax. Is that right?
Yes, sir.
Okay, and Austin at the time thought that Tori's boyfriend Scoop was a bad influence because Scoop was introducing Tori to these drugs. Is that right?
Yes, sir.
Okay. March 29th, 2022 was the first time you met Austin face to face?
Yes, sir.
And that was there in the jail at Clayton County. Is that right?
Yes, sir.
Okay. when you met with Austin, you knew at that time that he was under 21, is that right?
I did.
Okay, and part of that was the fact that he had been arrested in Clayton for a gun after the police were called, after him and his girlfriend got into an argument about his ability to take care or not take care of her financially. Is that right?
Yes, sir.
Okay. And I think you asked him about that. Why not just go to a pawn shop? And then, of course, you reminded yourself that he was under 21. Is that right?
Yes, sir.
Tori and Austin were about the same age. Is that right?
Yes, sir.
I understood that they had been friends for a while. Did you understand that they had been going to school together during the time that they were friends?
Yes, sir.
Do you know if they were in the same class, like same 7th grade, 10th grade together?
I believe they met in 9th grade. I don't know if they had classes together.
Okay. Austin told you when you spoke to him down in Clayton County that he was trying to take care of his girlfriend and her baby, which was not his child. Is that right?
Yes, sir.
Okay. And did you think that Austin, when you were calling Austin prior to meeting with him on March 31st, March 29, 2022, did you think that Austin was sort of avoiding you, or just life was just beating him up?
In my opinion, I felt like he was avoiding me.
Okay. Because you had given him sort of every opportunity to meet with you. Is that fair to say?
Yes.
You had offered to come to him. Is that right?
Yes, sir.
But he was bouncing a little bit. Is that fair to say?
Yes, sir.
He was never really in one place. He didn't seem to be stable. Is that fair to say?
Yes, sir.
Okay. Austin, during the recorded interview, indicated that Tori shot herself. Is that right?
Yes, sir.
He repeatedly said he never shot her. Is that right?
Yes, sir.
And Austin said to you during the interview, I thought he said this, that he never saw her fall. You recall him saying that? Never seen her fall.
He told me that she fell. I believe he said something that he didn't look at her afterwards, something to that effect.
Okay. Did Austin indicate to you whether or not he had to take the gun out of her hand or if the gun fell after she shot herself?
He said the gun fell out of her hand.
If I understood your testimony correctly, you had to call out the Hall County dive team?
Yes, sir.
Hall County.
Yes, sir.
I thought it may have been Rockdale for a second. Hall County, which is a county north of Gwinnett.
Yes, sir.
Okay. Austin told you that he had dumped the gun in Hall County?
No, sir.
How did you get to Hall County?
We just have a relationship with their dive team, and we use them often.
Okay. So Hall's dive team, does Gwinnett have a dive team?
No.
That may be the reason. So Hall's dive team comes to DeKalb.
Yes, sir.
There we go. I got you now. And which body of water did they search in DeKalb?
It was a private residence off of, I believe, Ashbury Road, or Ashbury Lane, I believe. It was the speed bump road that he referred to in his interview because it legitimately had multiple speed bumps.
I got you. And about how far was that body of water from Yellow River Park as the crow flies?
2.5, 3 miles.
Okay. And was it about the same distance from Austin's apartment?
Yellow River Park or the pond?
The pond.
No, it was like maybe 1/4 mile,
Okay.
if that.
So the body of water was closer to Austin's home than it was to Yellow River Park. Is that right?
Yes, sir.
And Austin's residence is probably only about 5 minutes away from the park. Is that fair to say?
If you're driving,
Yeah, driving.
5 to 10 minutes, maybe 15.
Yeah, you come out of his apartment, make a left on 124. You go to the second light after Rockbridge, make a left, and you're almost right there on top of the park. Is that fair to say?
Yes, if you take that route.
Okay. Is there a faster route?
I don't think there's a faster route, but the way that when the Google records came back on, there's another way you can take a left off Juhan and out of the front. So there's 2 entrances, like on Juhan.
Yes.
you can take a left out there, go down Annistown, and kind of go back the way that the records show him going there. And that would put him on Rockbridge Road, and that's when his phone had turned back on. Well, started pinging again.
Yes, if in fact you leave if in fact you leave the parking area of Yellow River Park near where Tori's body is found, you can exit Juhan Road onto Annistown Road. Is that right?
Yes, sir.
Okay, we got that. No gun was ever found by the Hall County Dive Team, was it?
No, sir.
Okay. Austin's apartment, it's about 5 miles from Stevenson High School. Do you know where Stevenson High School is?
I do have an idea of where it is, yes.
Is his apartment about 5 miles from Stevenson High School?
I don't know for certain, but yeah, that seems about right.
Okay. And the burnt, I'm gonna call it burnt out vehicle. The burnt out vehicle is less than half a mile away from Stevenson High School. Is that right?
Yes, sir.
Okay. The prosecutor asked you a question about speaking with some folks at the DA's office. Do you testified that you spoke to some folks at the DA's office before taking any arrest warrants? Is that right?
Yes, sir.
Did you speak? Who did you speak to?
It was a group of people. I know Sabrina was in there, Sabrina Nazim, Daryl Manns, I believe the investigator Whaley. There was multiple people in there.
Okay, so you were speaking to the top brass in the DA's office at the time when you were speaking to them. Is that fair to say?
Yes, sir.
Okay. And did you speak once or more than once? Do you recall that?
I communicated with them throughout my investigation, Sabrina in particular, but I only met with them in person one time.
I got you.
Prior to taking the warrants.
I got you. What date was that? What date did that conversation take place? Do you recall that?
It was between March 29th and April 15th.
April 15th. Does that represent the date you took the warrants?
Yes, sir.
April 15th, 2022. Is that right?
Yes, sir.
Okay.
And I believe the meeting was probably either the day before or actually the day of April 15th.
Okay, and then sort of after speaking to the DA's office, you made the decision to take the warrant for felony murder and for aggravated assault. Is that right?
Yes, sir.
Okay, so when this indictment that the jury will have out with them comes back, you didn't take a warrant for voluntary manslaughter, did you?
Objection, Your Honor, relevance.
What's the legal basis for just relevance? I mean, it is a charge on the indictment, so why would it not be relevant?
Whether or not Detective Carter took a warrant for it's not relevant.
I'm going to overrule it. She's on cross-examination. I'll allow it.
You didn't take any warrant for voluntary manslaughter, is that right?
That's correct.
Okay, and you didn't take any warrants for any theft by taking of any gun or theft by taking of a vehicle, is that right?
That's correct.
Okay. But you did testify at the grand jury that returned the indictment, is that right?
Yes, sir.
All right. I don't have any further questions. Thank you very much, Judge.
Redirect.
Does the fact that you did not take a warrant for theft by taking, for example, mean that somehow a theft by taking did not happen?
Judge, I think that's up to the jury. I don't think that's up to her. I'm going to object to that question. That's for the jury.
Listen, you opened the door about whether or not warrants were taken versus what was indicted, so I'm going to allow Mr. Norris Lewis to follow up on redirect.
Yes, Judge.
Can you repeat the question? I'm sorry.
So does the fact that you did not take a warrant for theft by taking mean that a theft by taking did not happen?
No, it's actually pretty common for us not to take all of the warrants that may be according to, fit to the case for you guys.
And so, which leads to which kind of answers my next question, which is, do you take every warrant for every single offense in every single case that you have?
No.
When you met with Dr. Terry, were you asking specific questions that you had about the case?
Yes, I was kind of brainstorming because I was still coming into the case and trying to think of scenarios.
Did you ask specific questions about the positioning of the body when Tori was shot?
Yes.
What, do you recall what questions you asked?
We were discussing in regards to her hands.
Okay, so the questions you had more to do with the position of her hands,
Yes.
less so with the position of her body as a whole.
Yes.
And when you investigate something, I mean, I guess the art of it, or the act of investigating, is trying to find out about something. Do you explore avenues that don't always pan out?
Yes.
Do you sometimes talk to people who have no information?
Yes.
Do you sometimes look down a path and find that this is not the path we need to be on?
Yes.
Is that the nature of investigation?
Yes.
That's all the questions I have. Thank you.
Recrossed.
Testify, you normally don't take every warrant that you can, is that right?
Yes, sir.
All right, right. And the prosecutor's office ultimately has the final say on what charges go on the indictment. Is that fair to say?
Yes, sir.
But you conferred with them before you ever took any warrants. Isn't that right?
Yes, sir.
Right. No further questions?
We redirect.
No, Your Honor.
All right, is Detective Carter excused by both sides?
She is, Your Honor.
No objection, Judge.
All right, Detective Carter, you can step down. You're excused from any further appearance.
Thank you, Your Honor.
Call your next witness.
Your Honor, I believe I have tendered, and the following exhibits have been tendered and admitted. 1 through 43, 45 through 58, 60 through 63, 15 sub A, B, C, D, E, F, G, and H.
I don't know, but the record will reflect what exhibits have been tendered.
Of those exhibits, if they have not been tendered and admitted, I tender those exhibits. I believe all have been admitted, but with that, the state rests.
All right, members of the jury, the state has rested, which means they have closed their portion of the evidence in the case. At this point, I'm required to take up some legal issues with the attorneys arising out of the state resting at this point. So let me have you just take a recess. They can be at ease for probably at least 15 minutes, and then I'll have an update on scheduling, but we are on track as planned to get this case to you shortly. So let me just plan for a 15-minute recess with an update on scheduling. Leave your notepads and pens here, and remember your precautionary instructions, please. Give me just a moment. Give me just a moment to have Ms. Wofford step in for me, please. While I'm waiting for Ms. Wofford to come in, let me inquire of Mr. Lawrence Lewis and Mr. Austin Ford, but Mr. Lawrence Lewis on his behalf. Did you have any further discussion, or do you need to have any further discussion with Mr. Ford on his decision to testify or not testify?
I apologize for going out of order, Judge. Respectfully, I don't have any motion for directed verdict. I'll put that on the record.
Okay, well, all right, I was going to ask Ms. Wofford to come in for that, but
Oh, sorry.
that's fine.
That's fine. So I want to make that clear. Judge, I don't have it, I did not speak to Mr. Austin Ford any further. I don't know that anything about his position has changed, so I don't have any objection to the court inquiring of Mr. Austin Ford directly if he wants to speak to me some more about that particular issue and whether or not he's going to get on the stand, or if he's already made a decision that he's not getting, that he's going to maintain his position and he's not going to get on the stand.
So let me inquire of you before I touch on that issue again. In the event that Mr. Ford maintains his earlier position to not testify, do you then intend to rest your case?
I do.
All right. Mr. Ford, do you recall yesterday that I went over your rights and your choice as to whether or not you testify or not testify during your trial? Do you want me to go over those rights with you again today? All right, I will do so at this time. Mr. Ford, do you understand that you have a right to testify, and if you want to testify, that no one can prevent you from doing so? Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not wish to do so? Do you understand that not your lawyer, Lawrence Lewis, but you personally are the only one who decides whether you will testify or not testify? Do you understand that if you choose to not testify, then upon a request of your lawyer or by you, I will instruct the jury that your decision to not testify cannot be used against you? Do you understand that if you choose to testify, that you will both be questioned by your attorney and cross-examined by the assistant district attorney? Having had these rights explained to you, do you want to testify or not testify? Have you understood all of the rights as I have explained them to you?
Yes, ma'am.
And is your decision to not testify your decision?
Yes.
Have you had enough time to talk with your lawyer about that decision?
Yes.
Do you need any additional time to speak with your lawyer before making that decision final? All right. Having found again that Mr. Ford has been advised of his rights regarding testifying or not testifying, finding that he understands those rights, I find that he has made a voluntary election to not testify with a complete understanding of those rights. With that being said, I'd ask Ms. Wofford to step in for the motion for directed verdict, but as I understand it, no motion for directed verdict will be made by the defense. Is that correct?
That's correct.
All right, so now that the evidence is closed on both sides, when I bring the jury back in, I will allow Mr. Lawrence Lewis to rest on behalf of the defense, but I want to take these 15 minutes to go over the request to charge so that we can finalize those over the lunch recess. If everyone can pull out their request to charge that were provided this morning, as well as the proposed verdict form. And did I give one to the court reporter? Yes, okay. All right, so I'm just going to go over the areas that needed to be revisited after the preliminary charge conference that was held last night. So we are on the bottom of page 2, which is 1.32.10, the defendant's choice not to testify. Now that that decision is final, do you wish for me to give that charge? Mr. Lawrence Lewis.
I do, thank you, Judge.
All right, and bear with me because I'm going to try to clean this up on the computer as we go. Give me just a moment. All right, so that is the pattern charge, 1.32.10, and I will give that in its entirety. All right, and then that will take us to the bottom of page 3, 1.32.23, after exercising Miranda rights and reinitiating conversation. I believe the red portion is no longer applicable. That would relate to whether or not Mr. Ford took the witness stand.
Agreed, Judge.
The state want to respond?
I actually don't believe any of it's necessary. The defendant did not at any point exercise his Miranda rights. He never requested an attorney. He did not exercise his right to remain silent. he simply
I understand that was your position last night, but that is a determination for the jury to determine whether or not any of those rights were invoked or not. So I will give the pattern charge, but strike the red language. All right, then that takes us to the top of page 4. Again, that one sentence at the top of page 4 would no longer apply since Mr. Ford has elected not to testify. So I will strike that red sentence. Anybody want to weigh in on that?
No, thank you, Judge.
All right, then 1.34.00 was a pattern charge on limiting instructions, but it did not really fit the evidence in this case, so I have crafted my own language. So this is the court's instruction or a version of it that was given during trial. Let me have each of you, well, let me strike out the second paragraph that starts with additionally. That will be struck in its entirety because that relates to redacted evidence, which we did not have. So it would just be that first red paragraph. If you all will review that and tell me if there are any exceptions.
None from the state, Your Honor.
None, thank you, Judge.
All right, so that's what I will give. And then we are on the bottom of page 5. We were revisiting good character of the defendant, and no information, no evidence was presented as to that, so I will strike that in its entirety.
Yes, Judge.
Any objection from the state?
No, Your Honor.
All right, so that will be struck in its entirety. All right, on the middle of page 6, we have no one requested, but we also have no evidence of accident, 1.40, 1.30. So I intend to strike that in its entirety. Any objection?
No, Your Honor.
No, Judge.
All right, and then that brings us to, all right, the top of page 8, I just had a bench note to address with the issue of felony murder and provocation, but I'm just going to remove that bench note unless anybody wants to be heard. That was just for me to think about as these were being prepared.
I have no objection, Judge.
All right, and give me just a moment. And not hearing anything from the state.
I just didn't think I needed to weigh in on whether or not the court was going to read the bench note.
No, it wasn't for me to read the bench note. It was whether or not I needed to address anything that was outlined in the bench note. But
No, you did not.
okay. All right, then that takes us to the bottom of page 8. And I have crafted, let's see, 2.64.43 as well as 2.64.44 to make the distinction between the two theft charges, one that does require a finding of value and one that does not. So please read both of those and let me know if there are any exceptions. I think I'm going to change just the very last sentence to say, but value does not have to be proven by the state beyond a reasonable doubt for the item alleged to have been taken in count 6 of the indictment, the firearm. Instead of just, but does not have to be proven, but value does not have to be proven.
Okay, I see where you're at. Yes, Judge. That's fine.
Any exceptions from the state?
No, Your Honor.
And any exceptions from the defense?
I don't have any exceptions to what the court's suggesting or to the
convert that over to be given as written. A moment. All right, that takes us then to some defense charges, nothing, affirmative defense.
I'm going to withdraw that, Judge.
All right, so 3.00.00 will be deleted. Then that gets us to the series of justification charges.
I'm going to withdraw, you didn't, on this one, you didn't necessarily write D16 or D17, but I'm going to withdraw justification, and use of force in defense of self or others, reasonable belief explained, and no duty to retreat. Everything in red, I'm going to be withdrawing, Judge.
All right, any exceptions from the state?
No, Your Honor.
All right, so all of those will be deleted in their entirety. And I believe that's it. So does anybody want to take a moment to just read through that one last time before I bring in the jury? See if there's anything else that anyone wants to note on the record. Otherwise, with the changes that we discussed, that will be, well, before you do that, let's go over the verdict form. So on the verdict form, there's nothing unusual or unique. Counts. One gives the option of guilty or not guilty. 2, guilty or not guilty. 3, guilty or not guilty. When we get to count 4 and 5, I've just delineated that count 4 is possession of a firearm during the commission of a felony, that felony being murder, giving the option of guilty or not guilty. Count 5 is the possession of a firearm during the commission of the felony of aggravated assault, giving the option for guilty or not guilty. On count 6 and 7, the theft charges, I've identified them as count 6 is the firearm, which is guilty or not guilty. Count 7 is the theft by taking of the vehicle. It is indicted for a vehicle with a value of $5,000 or more. So they have the option of guilty of $5,000 or more, or guilty of the lesser offense if they do not believe the value of a value between $1,500 and 1 cent, but less than $5,000, or guilty of $1,500 or less, or not guilty. So, I mean, the jury has to make a finding as to value based on the evidence. So these are the increments that are provided. And depending on the evidence, they will have to say not only guilty or not guilty, but at what value level. Anybody have any exception to that?
No, Your Honor.
No, Judge.
All right, and then count 8, the concealing, just gives the option of guilty or not guilty.
Judge, on the indictment, it reads tampering with evidence.
Not on my indictment.
Oh, is that?
00981-3.
Okay, that's just on the lead sheet then.
Yes, no, I'm looking at the indictment where
Count 8.
issue was joined. Count 8 says concealing death of another.
Oh, okay. I may have it. Oh.
Do you want to look at it to satisfy yourself? This is the indictment where issue was joined.
It's the re-indictment. Got you, Judge. Thank you.
Yep. All right, no issues with the verdict form from the state,
No, Your Honor.
from the defense?
No, thank you, Judge.
All right, take one last read through if you want of the charge with the omissions, and I think I've made all of the deletions, Lisa, so if they say good, I'm going to send it to you for copies. Let me just check spacing. And then, Mr. Umberg, I'm going to keep them all together for lunch today and pick up their lunch. And if you will be very mindful of making sure that only jurors make it into the juror lunchroom. Okay, so just keep your eye on our jurors and their badges, because we had an incident yesterday. All right. I'm just pausing to wait for each side to let me know that they're satisfied with the final version, deleting and amending anything that we've just discussed.
The state's satisfied, Your Honor.
All right, then give me just a moment. Then I'm doing my last read through for spacing, and what I would intend to do in just a moment is to bring the jurors back in to allow the defense to rest. I will send them to lunch, and we will do closing arguments right after the lunch hour.
Yes, Your Honor, that's state.
All right. All right, I'm sending it to you now. Does either side wish me to email the court's charges to them?
No, Your Honor, it's not necessary.
All right, let's bring in the jury. And you can be excused. Yes, I just emailed you. So we
12 copies for the jury, or 14.
12, and me and Christine. 13, 14,
Well, I know how many
15, yeah. 12 for them and then all of us. And you don't need to make the verdict form is final. Would you just do a check through and make sure everything's spacing is good before? All right, thank you. All right, the state having rested its case, I will turn to Lawrence Lewis. If you will please call your first witness.
Judge, respectfully on behalf of Mr. Austin Ford, the defense rests.
All right, members of the jury, the defense has rested their case. Any rebuttal evidence from the state?
None, Your Honor.
All right, ladies and gentlemen, the evidence is closed for both sides. Due to the hour, we are prepared to move forward with closing arguments, but the closing arguments in charge of the court on the law will be fairly lengthy, so I'm going to give you your lunch break at this time. When you come back from lunch, we will begin closing arguments and instruction from the court on the law, which will allow you to begin your deliberations. Once the case is turned over to you for your deliberations, we will be on your schedule. So that means you determine when and if you take breaks, how long you take breaks, and how long you want to stay to deliberate. So we will be on your schedule. You will let us know that. I'm going to keep everybody together for lunch today, and the court will pick up your lunch. Let's be in recess for lunch until 1 o'clock. So please be complete with lunch at 1 o'clock, at which time we will be ready to present closing arguments and the law to you so that you can begin your deliberations. Please remember, your precautionary instructions over the lunch break. All right, anything from the state before we recess for lunch?
No, Your Honor.
From the defense?
No, Judge, thank you.
All right, we'll be ready for closing arguments at 1 o'clock. Thank you. Mr. Ford's back with the deputies.
I first needed the court to be aware before I. When you get it out.
All right, thank you. Let me give these to you right now, Mr. Umberg. That's going to be the 12 copies of the jury charges. I'll give you the verdict later.
You want these handed out when you read the charge, or just?
No. Just hold it off to the side. When you take the evidence into the jury room, that will go with it. All right, we have everybody ready?
We do, Your Honor.
All right, let's bring out Mr. Ford, please. All right, going back on the record in the state of Georgia versus Austin Tybee 423B00981-3. Everybody, including Mr. Ford, is present. Is the state ready for the jury?
It's ready.
The defense?
Yes, Judge.
All right, let's bring in the jury. Everyone, please check your phones. All right, Members of the jury, the evidence having been closed for both sides, we will now move into the next phase of the jury trial process, which will be closing arguments or summation from the attorneys. I remind you that what the attorneys say in closing argument is not evidence. The evidence comes from the witness stand and from the documents and exhibits that have been admitted for your consideration. All right, do we have a closing argument? Well, let me ask the state, do you intend to give an initial and a concluding argument?
I do, Your Honor.
All right, then we will hear from you first, then Mr. Norris Lewis on behalf of the state.
The other Mr. Lewis, in his opening argument, spent a very long time calling this case weird, calling the indictment weird. Yes, this case is unusual, inasmuch as murders are usual things. It is unusual for two best friends to go in the park, for one to leave and the other to stay there with a gunshot wound to the head. It is unusual for one of those best friends to take the gun away from the scene of what he calls a suicide and throw it in a pond somewhere in DeKalb County. It is unusual for one of those best friends to drive that car away, to drive the other best friend's car away, and it turned up burned to the frame in a nature preserve in DeKalb County. It's unusual for that best friend to then lie to his best friend's mother on the day where she's missing, where she's wondering where her child has gone. And he's going to say, I don't know where she is. When he knows full well he left her dead in Yellow River Park. It is unusual for him to then, as now a grieving best friend who, at least the way he portrays it, is that I just lost my best friend to suicide. For him to skip the vigil at the scene. Oh, unless he's not ready to go back to the scene where he shot her. It's unusual for him to continue attending her funeral, calling her mother, talking to her mother, hugging her mother, knowing exactly what happened and what he did, what he had to have done in Yellow River Park. It's unusual for him to carry these lies forward and to tell more lies and lie after lie after lie to Gwinnett County investigators for 8 full months. It's unusual for that best friend to, when he's finally coming clean, not coming clean because his conscience got the best of him, he just wanted to tell the truth now. No. He's coming clean because he got caught in his lies, because his phone told on him, because we know where he was. We know when he turned his phone off. We know when he turned it back on. We can see that he went someplace that he could not have walked to. He finally came clean, and he tells a story that just clearly does not match the physical evidence. So yes, this case is unusual, and it's going to lead to unusual things, unusual indictments, and unusual testimony. John, I'll reserve the rest of my time to conclude.
All right, thank you. Do we have a closing argument on behalf of the defense, Lawrence Lewis?
As I come to the end of my legal career, I find myself often thinking about the beginning of my academic career. And it's sometimes unusual because I don't have all the facts from high school, but I always have two salient features anytime I think back to high school. The first thing I remember throughout all of high school and colleges, I actually believed that if I studied hard enough, I could understand people. If I really did my history lessons and sociology and religion, and I studied English literature, I would be able to understand why people do what they do. I don't know if that was naivete or hubris, but I believed that right up until the time that I saw the proliferation of cell phones. And that's when I knew, checkmate. There's no way in the world I'm ever going to be able to figure out why people do what they do. Second thing I always thinking about is this sort of low-grade anxiety. And I think probably all teenagers have it. You're not quite grown. What's my life going to be? What type of man am I going to be? Am I going to be able to find a partner that'll sort of appreciate my little idiosyncrasies? And I call it a low-grade anxiety because that's now part of the culture, part of the American culture. Mental health is a part of the American conversation. And nothing about my anxiety caused any interference with my schooling, nothing about what I felt impacted my daily life. I didn't need to take any medication. Of course, you know I went to school in the early 80s. The early 80s. It was very simple then. There was no internet, and I think home box office, HBO, was the only thing that was hot in the street at that time. And inside of my 80s bubble, suicide was just a word, like socialism, some type of esoteric concept. It wasn't anything real. It didn't touch me. I didn't know anybody that had committed suicide. I didn't know anything about suicide. Of course, this was before I studied Sigmund Freud. This was before I read On Suicide by French sociologist Durkheim. This was before I studied John Piaget. This was before I read Marx. So, I mean, I was young. I was sort of clueless. Suicide, we know now, is a national epidemic. We know that now. We know that now. Mental health dominates the cultural dialogue. And we also know that young people are constantly being bombarded on the internet and social media with all sorts of images of what they should be, all sorts of anxiety-producing images. We know that now. A great deal has changed in the 40 years for me since high school. A lot has changed for me, a lot has changed for the society. Even in the almost 3 decades that I've been practicing law, a lot of things have changed. I never would have dreamed when I was a young prosecutor in Philadelphia that a prosecutor would depend 100% on a homicide conviction on the fact that the defendant told a lie. I wasn't there. It doesn't really matter how many lies fall from that first lie. I wasn't there. I told you that in the opening that he lied. But I never would have dreamed as a young prosecutor that I would be here some almost 25, 30 years later, and the entire case would rest on my clients telling a story. And of course, that's compounded and made more ironic by the fact that 85% of American culture is on the internet lying, pretending to be something that they're not, pretending to have things that they don't have. So now, honesty determines if you're guilty of murder or not. Not evidence, honesty. So, as my father loved to say, a liar will do anything. Let's be honest now. Let's talk honestly. Let's do it. We all understand the world that challenged Tori Lang as a 5'10", 237-pound female black teenager. We all understand the challenges that she faced. Between May of 2020, when she graduated, and July of the following year, that 14 months, we were under COVID restrictions. What did that mean? I remember that because I had to walk a quarter mile in Wade Walker to get to the baseball field to train the boys because the police had cut off the part of the park where all the young people were gathering. They were so tired of being cooped up in the house after 90 days, they would have these spring-up parties, and they would take over the park. And DeKalb County came and closed certain sections of the park, so I had to park near the tennis courts at Wade Walker and walk a quarter mile with all the baseball equipment and the boys because young people were going crazy being at the house. During that time, we know that Tori was on Instagram. Let's be honest now. Let's be honest. The only value a woman has on Instagram is her face and her figure. Let's be honest, if we're going to be honest. We know Tori's feeling that pressure because we have the testimony of the witness that told you what Tori is taking diet medication, prescription diet medication. She's feeling the pressure of being on Instagram. Let's be honest. Let's be honest. Of course, like any normal teenager, she's bucking up against her parents because she wants to be an adult and is not yet ready to be an adult, and half of the world is closed. DeKalb County's closed. She can't do it. She doesn't have the economic resources to do ultimately what she wants to do. And we know she's suffering from some type of depression, emotional fragility, whatever you want to call it. Her mother told you freshman year she was hospitalized. When the officer, the first assigned officer, went to see mom, what did they tell him? She was suicidal, Detective Smith. Mother told Detective Smith she was suicidal. Marchese, not Austin Ford, also told him. So he had two separate people who were intimately connected to Tori telling him, the lead investigator, Tori was suicidal. So we know exactly how Tori comes to be at Yellow River with her mother's gun, laying on her back at night, looking up at the tree. We know exactly how she came to be there. So the question is, do we need somebody to blame for that? That's the real question. Do we need somebody to blame for that? I want you, when you come here, when you go in the back and you deliberate, I want you to bring your common sense and experience. But you know what I want you to leave out there? I want you to leave this new American zeitgeist. I want you to leave it out there. What am I talking about? This anytime I don't get what I want, anytime my feelings are hurt, I'm a victim. And I need somebody to blame. I need some oppressor. Leave that out there. Nobody grew up with that. That's new. That's new COVID, post-COVID thinking. We don't need that. Leave that paradigm out there. People get hurt all the time. There are car accidents all the time. You're not a victim every 2 seconds. Leave that out there. All during voir dire, you heard the prosecutor asking you the same question over. What would you do? What would you do if somebody told you it was suicide? What would you do? What would you do? I would do almost anything. And he's setting it up for you. He's setting it up. Somehow it's Austin Ford's fault because he didn't do enough. It's somehow Austin Ford's fault because he ultimately didn't do enough. So I guess that's it then. We do need somebody to blame. I guess that's it. Maybe we're answering that question. We need somebody to blame for Tori being in Yellow River Park with her mother's gun laying on her back at night, looking up in the trees. So we're going to pick Austin. Austin? Austin Ford? Austin didn't create the internet. Austin didn't invent the cell phone. Austin doesn't work for Apple. He's not on the marketing team that's got the children addicted to the cell phone. Austin's not setting the standard for women on social media. Austin's not responsible for that. Austin didn't bring us COVID and the mental health problems that came with COVID. Austin didn't do that. We know Austin's not the reason that the suicide rate has been going up since '02. That's not Austin. That's not Austin. It's not Austin's fault that people on social media have anxiety when they're on social media, and when they try to get off social media, they're anxious. That's not Austin's fault. But we gotta have somebody to blame for Tori being there. So, let's be honest, if honesty is paramount. Let's be honest. Austin's not the reason. Thursday afternoon, so you're going to have the case about 24 hours earlier than I expected you to have the case. The case lasted basically less than 2 days. Wasn't a long case. What are the undisputed facts? Undisputed. Tori took the gun from her mother's residence. That's undisputed. Tori drove her vehicle to Yellow River Park. Her vehicle to Yellow River Park. My client didn't pick her up. She drove her vehicle to Yellow River Park. Tori was experiencing some type of mental distress. Detective Smith tells us that when he tells us, I was assigned, I went out to talk to the people that knew her the best, and they said she was suicidal. She was suicidal. That's what we know, undisputed. Tori laid down under a tree voluntarily. That's undisputed. How do we know that? We know that because there are no defensive wounds, no scrapings were done under the fingernails based on the medical examiner's experience. She looked at her. Yes, they did a rape kit. There's no sex, let alone sexual assault. She's dressed the same way in the park as she is in the Ring camera. There's no question about that. These are the undisputed facts. Tori turns her gaze to the night sky and a bullet enters her head. Those are undisputed facts in the case. Undisputed. And so with those undisputed facts, you really only need to determine one of three things. That's what you're going to go in the back and deliberate. Did Tori shoot herself? Dr. Terry tells you that's very much a possibility. The science, speaking through Dr. Terry, says that's very much a possibility. I cannot rule out suicide. That's door number one. Door number two, did Austin shoot Tori? If we believe Austin, and Austin's the only person that puts himself there, if we believe Austin, he was present, and certainly it's possible he could have shot his friend of 10 years with no motive. That's weird. And prosecutor's not gonna come up here and offer you any kind of motive, because there's none. The third option is Austin assisted Tori in a suicide. He assisted. Homicide, suicide, he assisted. There's no evidence of that. There's no evidence that Austin assisted Tori in any type of suicide. That's just random speculation, like count 3, voluntary manslaughter. And you're going to have, the judge is going to read the indictment to you. You're going to have the indictment in the back. There is absolutely no sudden, violent, and irresistible passion resulting from serious provocation. That just doesn't exist. That's just made up. Just made up. Out of thin air. Remember, the last investigator told you she came and sat down and spoke with the DA. After she spoke with the DA, she figured she was going to take these charges. Aggravated assault and felony murder. Where's this voluntary manslaughter come in? What evidence is there? Well, we're going to throw that up and just sort of see if it sticks. Really? We got it. In an effort to help you choose one of these three doors, homicide, suicide, assisted suicide, the state presented 14 witnesses. And as far as I consider it, Austin Ford is a witness because you heard his statement. 13 witnesses, you've heard from 14 people. They called 14 witnesses, but only 6 were truly helpful. The first assigned detective, Sergeant Smith, he was the initial lead investigator. What did he tell you? He learned that there were no witnesses to the shooting. Nobody ever saw Tori drive into the park. Nobody ever saw Austin drive out of the park. There are no witnesses. He learned from Tori's mother and from, I believe it was Markezia Watson. You may have written down somebody else. Tori's mother and another person that was very important to Tori's life, that Tori was suicidal. And he gave that information to Dr. Terry because she included it in her report after she did the internal exam before he ever spoke to Austin Ford. So Austin Ford didn't plant that seed. Austin Ford didn't, oh yes, I knew it, and I think she was suicidal. Forget about that. Sergeant Smith was very clear. Found the body, talked to her mother, suicidal. Talked to another female friend, suicidal. Spoke to the medical examiner, she was, according to these other important people in her life, she was suicidal. Hadn't even spoken to Austin Ford yet. So there's no Austin Ford lying and planting the seed. That's not what happened. Dr. Carol Terry, medical examiner, 6,000 autopsies. He told you the external took an hour, the internal took an hour. I suspect she's super efficient with it by now. 6,000 autopsies. And what does the science say? The science says that we can't determine if it's a homicide or a suicide. Dr. Terry, by herself, is the physical embodiment of reasonable doubt. The judge is going to read you the instruction on reasonable doubt, and I'm going to talk about it in a minute. Dr. Terry's testimony, Dr. Terry herself, in my mind, is in fact the physical embodiment of what reasonable doubt is. The science is speaking through her. You cannot know. We don't know. You cannot know beyond a reasonable doubt. That was Dr. Terry. Dr. Terry destroyed count 3. She laid down and looked up. That's what, according to Dr. Terry, that's what the science says. Teresa Lang, she's the third witness. That was Tori's mom. She explained that Tori was hospitalized for mental health when she was a freshman in high school, and she also produced the rounds, the bullets, the brand which matches the 2 that were found in the park near Tori's feet. I don't care if you want to say 6 feet away, 8 feet away. That's all just silly conversation to me. That's all silly conversation to me. Why? Because Dr. Terry tells you that Tori's on her back looking up, and the gun is 10 inches away. And whether the gun is 10 inches away or 14 inches away, if you believe my client shot, she's looking up. The round discharges and it goes where it goes. There's no, if she committed suicide, it would have only gone 2 feet, but 2 more inches out, if it's a homicide, it would have gone 10 feet. That's all stupid talk. That's not even weird. That's just stupid talk. Where the rounds land have absolutely nothing to do with whether it's a suicide or a homicide. That was a waste of your time. Because we're only talking about a matter of inches. Because Dr. Terry's telling you, well, she's not laying on her back and it comes from, no. It comes directly from the side. Directly from the side. So any talk about how far out it went, that's all silly talk. Because the gun has to be 4 or 5 inches difference. Because if it's more than 4 or 5, then Dr. Terry's report changes. If it comes 4 inches in, then it has to be close range. If it goes even further out, that has to be long range. So we're talking about 4 or 5 inches is not going to change things in terms of the ejection of the round, 4, 5, 6 feet. So please, don't waste any more time on that. What else did Teresa Lang tell you? Teresa Lang told you she doesn't keep the firearm in the same place. Nightstand, vehicle, bag. And you have to use your common sense with that. Why is that? Well, maybe because she goes on long trips and she takes it with her. Or maybe when she goes, maybe that gun keeps moving because she understands her daughter's fragile and she doesn't want her daughter to know exactly where the gun is and when it's there. You get to use some of your common sense when you approach your analysis of the evidence. Investigator Stribling, he was asked to do one very specific thing. He can't tell us if the fire was electrical or non-electrical. Why is that important? I'm not quite sure why the vehicle got burnt up or how the vehicle got burnt up. I'm not quite sure. Remember now, my client and Tori are best friends. So why would he burn up the vehicle? That's one of those weird things again. If they find the vehicle and they say, hey, we found your hair or your fingerprints in the vehicle, that was my best friend. Why wouldn't you find that? Why wouldn't you find that in the vehicle? There's no reason for Austin to set the vehicle ablaze. Absolutely no reason. Ms. Muse was important also. She told you that she could not pull any fingerprints from the shell casings. That means that there was no evidence that Austin Ford ever loaded any gun, touched any shell casings, or touched any gun. That's ultimately what Ms. Muse told us. She couldn't pull any fingerprints of value. Now, that's some of that whole ejector port. I don't recall, you may have written it down. The gun, if it was Tori's mother's gun, does the ejection port go out left or right? I thought it was right. You can write it down. Maybe we didn't deal with it at all. So when the prosecutor comes up here and does his demonstration, if you wrote down ejector port right and he comes up here with any type of mock firearm with the ejector point left, you know it's more weirdness and games. Just come straight. Honesty is the main thing. Honesty, honesty, honesty. He wants you to convict him because he lied to the police. So hopefully he'll tell you the truth. In the search for the truth, at some point in time, you have to tell the truth. Austin Ford, his interview was played with the detective. The hour-long interview was played. He said, I wasn't there. Well, listen, you got common sense. If you tell the first lie, I wasn't there, there's going to be a series of lies that have to accompany that first lie that you weren't there. So this idea that we're going to go and count the lies that all stem from the same lie. Were you there? I wasn't there. Okay, when was the last time you saw her? That's got to be a lie. What was the last thing she said to you? That's got to be a lie, because you've already lied and said that you're not there. Got it. What's the other story he says? I was there, she ended up shooting herself. Can you understand how he might have panicked as a result of seeing Tori shoot herself? Can you understand why he may not have wanted to call the police even though he didn't shoot her? I think you can probably see that. Based on his testimony based on his statement to the officer at Clayton County, Austin Ford indicated that he removed the gun and vehicle after Tori shot herself. And he says, hey, listen, the optics just didn't look good. And maybe that's the reason. Or maybe, just maybe, his judgment was impaired by, you heard it, all the marijuana he's smoking. I don't know. That's what he's telling you about. We smoked, Tori and I went to get some smoke. I had some smoke, but I want better smoke. I didn't have Zaza at the house. You heard all of that. You heard all of it. Put it all in. The good, the bad, the ugly. You heard all of it. Maybe his judgment was just impaired. He told Detective Carter he was sort of, listen, I was tied up. And I believe he was tied up, as he explains it to you. He's got to take care of his girlfriend and take care of his baby that's not his, and he's trying to make all of this work, and he's trying to keep a roof over everybody's head, and he, of course, has the gun that he gets arrested for down in Clayton County because he's trying to protect the family, but he's not lawfully allowed to get a gun because he's not 21 years old yet, and, of course, he's arguing with his girlfriend because money's short. Yeah, I can understand that, but I told you in the opening, it's hard for me to believe 8 months. I got a good friend, my good friend is dead, and the police want to speak to me, and I don't, listen, I'm going to make some time. I'm going to make some time in the next week. I'm going to make some time. Yeah, I'm going to make some time. So Detective Carter and I probably are on the same page that he was dodging, but he does, in fact, talk to the police, and he tells them what happened. Once I sit down, the prosecutor, he's going to get up and he's going to speak to you. He's going to give you his version of what he believed the evidence shows. And once he sits down, unlike what you saw at trial, I don't get to pop up again. Mr. Lewis, you don't have anything else to say? That's a joke, right? If it's a pop-up game, we'll keep you here all night. He'll pop up, I'll pop up, he'll pop up, I'll pop up. He gets to speak to you last. So once he speaks to you, it's over. I don't get to speak to you again. The judge is then going to tell you the law. The judge is going to tell you the law. And part of the law that the judge is going to tell you is going to concern reasonable doubt. The embodiment of Dr. Terry's testimony about science. Reasonable doubt. What's reasonable doubt? Reasonable doubt, the judge is going to tell you, is the doubt of a fair-minded, impartial juror honestly seeking the truth. That's why jury selection took a day and a half, because we've got to have impartial jurors. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It's not a vague or an arbitrary doubt. It's a doubt for which a reason can be given after you consider the evidence, any conflict in the evidence. That's what reasonable doubt is, and the judge is going to tell you that. The judge is going to tell you mere presence is not enough. Even if you believe that Austin Ford was there in Yellow River Park, his being there is not enough. His not stopping Tori, you can probably figure that out. That's not going to be enough to convict him of murder. He didn't bring the gun. He didn't encourage her to do anything. The judge is going to tell you mere association is not enough. Just knowing Tori, being Tori's friend, that's not going to be enough. The mere association. Bare suspicion is not going to be enough. The judge is going to tell you that. The judge is also going to tell you that you can't hold it against my client that he chose not to testify. I think I understand why he didn't testify, and hopefully it makes sense to you. He told them, Austin Ford, he told them, the police, I wasn't there, I wasn't there, I wasn't there. They didn't believe any of that. And when he finally said, listen, I was there, he got the handcuffs put on, and there he sits. So I don't know that talking has helped him at all. I don't know that talking has made his life any better, so maybe that probably was the best thing. Let me just sit there and let the judge tell the jury that it's the state's burden of proving my guilt beyond a reasonable doubt, because this talking thing hasn't worked for me so far. It hasn't worked for me. Sympathy. The judge is going to instruct you that your verdict must be based upon your opinion of the evidence according to the law that she will give you in the charge. Your verdict cannot be based on sympathy. The judge is going to tell you it is your duty to consider the facts objectively without favor or sympathy to one party or the other. The prosecutor wants somebody to blame. I'm not mad at that, because that's the culture now. Somebody is to blame. If we meet in an accident in a circle, you're a victim and I'm a victim. We're all victims. Whose fault is it? It's the street design. It's always going to be any adversity. We're all victims, and somebody has to be to blame. Somebody has to be the oppressor. The judge is going to tell you about sympathy. Your verdict must be based on the evidence that you heard from the witness stand. You put that evidence with the law as you deliberate, and you reach a verdict on whether or not the state proved his guilt beyond a reasonable doubt. Not all doubt, beyond the science, because the science leaves you with a doubt. And because the science leaves you with it, listen, I'm not really worrying about count 8. Concealment, tampering, I could care less about count 8. It's not about count 8. It's about the death of Tori. Because once you determine, this science thing, no, I don't know. I think Tori committed suicide. That means count 1, count 2, and count 3 are not guilty. Do you believe that when somebody sees somebody else, a good friend, shoot themselves, they then start thinking, I'm going to intentionally deprive the owner of the vehicle when I don't even know the owner of the vehicle, because I think the owner of the vehicle is Tori. I'm going to deprive the owner of the gun and the owner of the car of their Nobody's thinking about that. I don't even know where those kind of charges come from in this type of case. Once you determine that it is a suicide, you can go right down the list. Not guilty count 1, not guilty count 2, not guilty count 3, not guilty count 4, not guilty count 5, not guilty count 6, not guilty count 7. And when you get to the last count, tampering, concealing, whatever it may be, you can find him guilty of that. Because under every single scenario, under the first lie, he wasn't there, under the story, I was there and this is what happened, he's got to eat that charge. As to the rest, what I ask you to do is follow the law, follow the evidence, and the only just verdict is not guilty on all the other counts other than the last one. Thank you very much, ladies and gentlemen. Thank you, Judge.
All right, thank you, Mr. Lawrence Lewis. The state, Mr. Norris Lewis, your final closing argument, please.
I'm going to take what's an unusual step from me and address the series of fallacies that you just heard from the defendant's lawyer. The first of which is that this case is based solely on the fact that the defendant lied. In 20 plus years as an attorney on both that table and this table, I have had very few cases where the defendant didn't lie, to be perfectly honest. In every case that I've had, the defense attorney gets up and says, the prosecutor believes this, the prosecutor believes that, the indictment's wrong. Literally every single case. The idea that this case is based solely on the defendant's story is literally just dead wrong. The state is not looking for a scapegoat. The state is not just looking for someone to blame, because someone has to be to blame for everything. I think you can tell by the gray hair on my face and the fact that there's no hair growing on the top of my head that I do not come from the generation that believes that everybody has to be to blame. Everyone has to have someone to blame, that nothing can be your fault. Now, what I'm here for, what I'm here about is the evidence, is the facts. The things that show you that what happened to Tori was clearly not suicide. We're talking about people who said that Tori had been suicidal in the past. Sergeant Smith talked to a grieving mother who just found out that her only child probably took her gun and was now dead. This woman's world had just been upended, turned upside down, and destroyed. The only thing she can think right now is 4 or 5 years ago, when she was a freshman in high school, she did a thing that got her hospitalized briefly. She didn't say, oh, she's suicidal right now, she's running around trying to kill herself. That didn't happen. Marquisa Brown, Marquisa Watson, whatever Mr. Lewis wants to call her, did not get on this stand and say, I talked to Tori yesterday, and she was just suicidal. She wanted to kill herself. She didn't want to be here. You know where that comes from? You know where that comes from? It comes from him. The person with the most interest in the case. That's where it comes from. He's the one who said it over and over and over again. You know what you didn't hear? You didn't hear anyone testify that they were asked by Tori to hurt them. Him. Only him. The person with something to gain for calling Tori's death a suicide. The proposition that Tori is feeling the pressure of being a teenage girl who is taking a diet drug and happens to have an Instagram account of saying that, oh, she's heavy-set, she must be feeling the pressure, so she must be suicidal. That is a wild assumption. Nobody said anything like that, not even the defendant. Those things could be true, but there's literally nothing to support that other than the lawyer's assumption. Yes, we did speak about suicide in ordeal. I have to couch how I say that sometimes, because I went to law school in Louisiana, so sometimes for me it's voir dire. But talked about that for a reason. We talked about that because based on the defendant's statements, we knew it was going to come up. And it would be irresponsible to the point of malpractice not to gauge the potential jurors' attitudes towards the topic that is largely going to be the defense. The fact that I talked about it in voir dire doesn't have a thing to do with the evidence in this case. The purpose of that entire process is simply to gauge your attitudes and your biases, and in as much as they can be identified to determine whether or not you're an appropriate person to sit on this particular case. Dr. Terry is by no means the embodiment of reasonable doubt. And I'll get into what Dr. Terry tells us and what those things mean when they are combined with what the other witnesses, what Abigail Musey tells us, what Kia Jimenez told us, what the nice ladies, Miss Carter and Miss Aparicio from the crime lab told us, and how all those things work together. Because as Detective Carter told us, this is an investigation. It's a total investigation. If Dr. Terry says, well, it's undetermined and we're done, then why do we need the Gwinnett County Police Department? Well, we need them because there's so much more to what happened than what one person has to say. And I discount nothing that Dr. Terry says. Not by any stretch of the imagination. She's a very intelligent woman. She very much knows her stuff, and that's why she said that in 6,200 or so autopsies, 700 teaching autopsies, she has seen exactly one person in a study somewhere else activate a firearm they committed suicide with their thumb, and they were looking down the barrel. The angle and the position of that gun when it fired and ended Tori's life is actually known. The orientation is known, and I'll demonstrate that for you later. But it's known. And what I'll show you is that it borders on impossible for Tori to have taken that shot, depositing that shell casing where it landed herself. And actually, both Abigail Musey and Kia Jimenez told you about semi-automatic firearms and ejection ports. Yes, they are on the right side typically, and Ms. Jimenez said on a P365, the ejection port is on the right side. The angle at which that shell casing is thrown is telling of which way the ejection port was pointing. Plain and simple. I'll explain that further. The fact that there are no fingerprints found on the shell casings of the defendants is immaterial. We know that it was Teresa Lang's gun. It was probably loaded when it came to be in Yellow River Park. And frankly, it was probably loaded by Teresa Lang. So the defendants' fingerprints on, or lack of fingerprints on, are not material to whether or not he pulled that trigger. Somewhat material that he took it with him when he left in Tori's car. Now, the way a theft is proven in Georgia, a person does not have to specifically think, well, I want to deprive the owner of this notebook, so I'll take this notebook and I'll walk away, and that's because I want to deprive the owner of it. No. That is, as I said in the beginning, those are words. Words are important. Words are used differently in the law than they are in common usage. And so the law requires that you find that they intended to deprive the owner of the thing. It doesn't mean that they had to think to myself, I'm going to deprive the owner of the thing. The evidence of that is that they did something with the thing that was not take it back to the owner. And so if I throw a firearm into a pond, I'm certainly not about to take that back to the owner. If I park the car in the cut, if I abandon it, give it to someone else, sell it, nobody actually knows what he did with the car. I can't tell you whether or not he burned the car into Cobb County. Even if I did know, that's a DeKalb County issue because it didn't happen here. Jurisdiction prevents me from doing anything about what happened in DeKalb County. Investigator Stribling was clear. That car burned exactly where you saw it, which is in DeKalb County, which if someone set the fire in DeKalb County, irrespective of whether or not it had accelerant, that's a DeKalb County problem. Reasonable doubt is not beyond all doubt. It is not to a mathematical certainty. There are no percentages that you should use to determine what reasonable doubt is. It is the doubt of a fair-minded juror honestly seeking the truth. And that's what we're here for, truth. Evidence comes in two different ways, direct and circumstantial. Direct evidence is what someone tells you they saw. When Kia Jimenez looked at the two shell casings and said, based on my knowledge, training, and experience, these appear to have been fired by the same weapon, that is direct evidence that those two shell casings, at least in her learned opinion, come from the same gun based on her observations. That there were no drugs other than a prescribed drug in Tori's system was the expert opinion of Denise Carter. That is direct evidence that Tori was not blitzed out of her mind. She was testing for cocaine metabolites and certain amphetamines, and there was no indication that there was a need to test for anything else. When Chris Aparicio tested the blood on Tori's thigh, we learned that that's her blood. We also know that that couldn't be her blood because she couldn't move afterwards, but it's direct evidence that that's her blood. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. So, if there is a shell casing in a certain direction from a body, we know it was fired by a semi-automatic firearm, we can gauge at what approximate direction, what approximate way that ejection port was facing. Based on the testimony of Dr. Terry, I can tell you exactly where that firearm was. Now, that's not direct evidence because no one saw, well, except for the defendant, but nobody else saw where that firearm was and could say, I saw that firearm in that position 10 to 12 inches from Tori's head. But it's circumstantially, I can tell you exactly where it was. There is no legal difference between direct evidence and circumstantial evidence. Evidence is evidence. And of course, there are rules of evidence. You did notice there were a couple of objections. You can only be shown that which is admissible. You are also the finder of fact. Part of being the finder of fact is that you judge the credibility and believability of each witness. Their opportunity to see, their opportunity to hear. But one major thing to consider in what a witness says is their bias in the case, their interest in the case, and whether or not their testimony is probable or improbable. There are 8 counts on the indictment. As I said, there are sometimes charges in the alternative. One thing about people is people are wildly unpredictable, and you never actually know what they're going to say. And so sometimes you include charges that don't immediately make sense. I won't say that. That's not true. Sometimes you include other charges because crimes can happen more than one way, quite frankly. But when I'm done, I will ask you to find this defendant guilty of counts 1, 2, 4, 5, 6, 7, and 8. Now, let's talk about what we know. We know from Dr. Terry, and these are facts, we know from Dr. Terry that the gun was about 12 inches from Tori's head when it was fired. That's based on her observations and the pattern of the wound, science. That it went straight across Tori's head. right around the front of her ear, straight across to the other side, severing her brainstem. Based on that, Dr. Terry was able to tell you that Tori was lying in the position in which she was found when she was shot. Blood flow, the pool of blood on the ground, the particulate matter on her legs, on the back of her shirt, the appearance that there was no drag marks, no indication on her skin, no abrasions. All of that tells us she was right there. We know there were 2 shell casings, and we know where they were. We can see their approximate distance and angle from Tori's body when officers come and ask they were found. We know that Tori was not alone. We know she wasn't alone because Tori wasn't going to move the firearm. Tori couldn't move the car. The firearm itself was never found. There was not even an idea of where to look for 8 or 9 months when any number of things could have happened to it. Could have sank deep into the mud in the pond. Could have been somebody else swimming, could have found it, picked it up, and carried it off somewhere. If that's even the right pond. If that's even the right point in the pond where he threw it. Depending on how far he threw it into the pond. Did other things fall into the pond? There's any number of reasons why the Hall County Dive Team couldn't locate that firearm. We know that the car was found in a nature preserve in DeKalb County. We know that it was burnt to the frame. We know that the defendant lied about being there. He lied about seeing anything. He lied about looking for Tori. He gave the police other people to look at. He tried to send them off in another direction. Don't look at me. Don't look at me. Look at him. Look at Scoop. Oh, Scoop would have done it. Scoop's a bad dude. You know, Scoop be hitting licks. Scoop be doing scams. He pops perks and Molly, and Scoop's bad. Look at Scoop. Scoop was completely cleared. He did not come forward and volunteer that he was there after 8 months because his conscience was getting the better of him, because the anguish that he added to this situation for the Lang family was just eating up at him. He got caught. Detective Carter figured out where he was based on where his phone was. Detective Carter figured out that he turned his phone off on the way into Yellow River Park. Turned it off. It wasn't pinging anywhere. Suddenly, just went dark. Someone tried to call it. His girlfriend tried to call it. Not answered, because it was off. Why you turn your phone off when you're going to the park at 11 o'clock at night with your best friend? Why does it come on shortly before you wind up home? We know there were 2 shell casings. We know that there were similar marks left by the gun that fired them. Most likely they came from the same gun. A SIG P365. We know that Teresa Lang owned a SIG P365 and that she had Aguila ammunition in the box in which the 365 was located. We know from Kia Jimenez and Abigail Musey how semi-automatic pistols eject shell casings, typically thrown out and to the right. SIG P365, which Ms. Jimenez was familiar with, has an ejection port on the right, and it throws out and to the right. We know what the condition of the ground was. It was wet, compact dirt. There was some vegetation, but it was largely just dirt. But it's not like a hard concrete floor that's been waxed within an inch of its life. A shell casing hitting that kind of ground isn't just going to skitter around, bounce off, and roll away. It's largely going to stay about where it lands. And like I said, based on Dr. Terry's findings, we know exactly where that gun was when it was fired, when the shot that killed Tori was fired. We know exactly where it was because we know exactly where Tori was. We know that blood on her thigh was her own and that she didn't have anything wild in her system. We know that the defendant turned his phone off going into Yellow River Park. It's not that he stopped answering it, it was still pinging near there. No. It was off. It was off so he couldn't be tracked. We know that for almost 9 months, he lied. He concealed the truth. He evaded police. He dodged them, giving up no knowledge that he had about Tori's death, knowing that he was doing everything he could to prevent them from determining whether or not her death was unlawful, whether or not he killed her. Based on this photo, we're looking down at Tori as she was found. We see where the wound was above her ear. We know that that firearm had to be 10 to 12 inches down here, which would be midway through where her forearm is right now. It had to be there. It absolutely had to be there. 10 to 12 inches, about the length of a sheet of paper from her head in that position, which means that in order to fire it herself, she would somehow have had to contort her right arm into a position to hold that thing 10 to 12 inches from her head. To add to that, we know where the two shell casings were. There's one further away. This one probably was not the shot that killed Tori. This probably was. It might be, it's a few feet, maybe 8 feet, 6 feet from Tori's body off to her right, which means that the ejection port from that firearm was facing this way. It was facing towards this shell casing, which adds yet another degree of difficulty to how Tori would have had to fire that shot if she in fact fired it herself. It borders on impossible. Impossible to the point of riding a unicorn, winning the lottery while getting hit by lightning. It's a 1 in a million thing, but is it impossible? No. Mr. Lewis said, oh, it's Dr. Terry said it's very much a possibility. That's not what she said. She said it is a possibility. Allow me to assure you that this is not a live firearm. It does not have a firing pin. It is incapable of firing around. It has been cleared with the Sheriff's Department, and that's why they have not jumped me when I pulled this thing over here. We know that Tori's head was in about this position when she expired. We know that, you know what, let me not do that way. That's not much better. But we know that on her right side, 10 to 12, I'm on the left side because I don't want to point at the audience, even though it's not a gun and can't fire. But we know that this gun was about this far from Tori's head. Now reversed, it was about that far from Tori's head. It had to be in line with the wound. Her head was on the ground, so the firearm had to be down here. Now, because the ejection port had to be to the right, this is the way this firearm had to be when it killed Tori. Which means she would have had to contort her hand, her own hand, in such a way to create this. So with the ejection port having to face towards my feet, I can only get this thing that way if I fire it with my thumb. And not only do I have to have it this way, but I have to produce a perfectly straight shot across the back of my head just in front of my ear. That borders on impossible. You cannot do that naturally, the way a firearm is naturally held. It's simply not possible that way. The only way it happens, and Dr. Terry did say that, the only way it happens is with your thumb. 6,100 to 6,200 autopsies she was the lead examiner on. 700 teaching, 20 years, 3 Georgia counties. She has seen exactly 1 suicide where the thumb was used. She has seen exactly 1 where the thumb was used. And that person was looking down the barrel of the gun. I'm not necessarily going to look down the barrel of the gun and play this thing of myself enough. But looking down the barrel of the gun, it was done this way. The only way Tori activates that gun herself is with her thumb. The only way she does it and produces that wound is if she produces a literal straight and level shot. What is more likely is that there was someone else lying next to Tori who pulled the trigger, probably lying prone. They would have been able to produce that shot. We know that the only other person there was the defendant. That's not basing a case on a lie. That's basing the case on an evidence. Oh, the lie is part of it. But that's not just, oh, he lied, he's guilty. That's ridiculous. Those scientific facts that Dr. Terry testified to, the wound path, her almost instantaneous death, that there is no movement after a brainstem is severed and her position at her death. What she did not know, and she had some indication, yes, but she did not conduct any investigation into the defendant himself. She did not know the entirety of his lies. She did not know anything about what his interview with Detective Carter was. She didn't know that his Google records placed in there. She didn't know where his cell phone records put him. She didn't know necessarily about the car that was torched in DeKalb County because she performed her autopsy 2 days before it was even found. Those things are not her role. The suicide notion comes from the defendant. The only person who we hear say that Tori was suicidal in July of 2021 is the defendant. Nobody else stood here, said that Tori asked them to hurt her. No detective who talked to anyone even said that someone said that. The only place that comes from was the defendant. That shot would be hard to reproduce shooting naturally by experience.
Pause for a second. Please step out of the courtroom. You are excused from the courtroom, sir. I apologize. Please continue.
It would be difficult for an experienced marksman to produce a shot that straight with no up, down, no left, right deviation. Literally straight across the brainstem. But I didn't want you to believe Tori did it with her thumb on a whim in the park while staring up at the sky. That's stupid. When he finally tells some modicum of truth, he's still lying. Because what he said, well, I had the gun, I got it from her, I put it on the ground. I tried to hug her, but she pushed me away, grabbed the gun, and just shot herself in the head. Seriously? With what Dr. Terry told us, is any of that even possible, let alone true? Never said he was at the park. Didn't mention the gun till he had to. Didn't mention the car till he had to. paints himself as some sort of white knight who was the only person who cared about Tori, who was the only one who recognized that she was in distress, who tried to help her. You can tell when he's lying and how he's lying based on the way he interacts, both in particular with Detective Carter in those 2 long interviews. And I admit that I hated playing interviews that long. I apologize for that, in as much as we had to sit there and listen to them. But what I wanted you to hear is how every second there's a pause, the defendant starts talking again. Starts talking to saying something else that favors his story, something else that makes him look a little bit good. Because he's trying to get Carter to believe the lie. He figures in his mind, one more sentence, one more word, she'll finally believe it. If I just say one more thing, it'll put her over the top. He does that throughout the phone call. He does that at the jail. Ladies and gentlemen, your job is to seek truth. Yes. It is your job to seek truth. All right? It is your job to seek truth using the entirety of the evidence, using the entirety of the investigation, the observation of Casey Smith, the work that Sergeant Smith did before he was reassigned, the work that Detective Carter did after she got the case. What Teresa and Tanya Lang told you about, not only about Tori, but about the fact that they didn't tell Austin Ford he could take their stuff and throw it in the pond or leave it somewhere to be burned up. Ms. Boone Perkins, who provided ring camera that partially debunked part of the defendant's story. Dr. Terry, who, while again she did find that the cause of the manner of death was undetermined, she did show us and tell us that it is wildly unlikely that Tori committed suicide. Did she use those words? No. But because it was possible, she couldn't change her ruling. Because something is possible doesn't make it likely, and it sure doesn't make it reasonable. And of course, Ms. Carter and Ms. Aparicio. I really just don't want the last image that you see of this beautiful, effervescent young woman to be her lying under a tree. But I do want you to go back into that room and find this defendant guilty of felony murder, aggravated assault, 2 counts of possession of a firearm during the commission of a felony, and 2 counts of theft by taking and concealing the death of another. Because looking at the evidence as a whole, in total, there is no circumstance that exists other than that defendant killed his best friend.
All right, Mr. Lewis, if you can remove your props and if you can move the podium.
Where would you like the podium, Your Honor?
Just push it out of the way for me, please. In just a moment, I'm going to instruct the jury on the law. No one will be permitted to enter or leave the courtroom while I am giving these instructions. They are lengthy, so if you want to leave, please leave now. All right, Ms. Floyd, please do not let anyone enter or exit the courtroom. All right, members of the jury, you are considering the case of the State of Georgia versus Austin Tyree Ford. The district attorney has indicted the defendant for the offenses of felony murder, aggravated assault, voluntary manslaughter, possession of a firearm during the commission of a felony, 2 counts, theft by taking, 2 counts, and concealing the death of another. The indictment has previously been read to you. And let me back up. You're each going to have your own individual copy of the entirety of these written instructions with you in the jury deliberation room. so you don't have to feel the need to take notes on them because you will have the entire instruction individually, your own copy with you. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate it or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After considering all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit this defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit this defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I am giving you to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. You as the jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testified, the nature of the facts about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observed it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. The testimony of an expert, like that of any witness, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his rights. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and made as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights, and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything he said, wrote, and signed could be used as evidence against the defendant in court. The defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. If the defendant exercises any of these rights, such as requesting an attorney, the police cannot question the defendant any further without an attorney being present. If the police initiate or continue conversation with the defendant after the defendant exercises such right, then any statement made to the police by the defendant after he exercises such right would not be voluntary, and you must disregard it entirely and completely in reaching your verdict. However, if the defendant solely on his own initiative, after exercising any such rights, freely and voluntarily requests and initiates further conversation with the police without an attorney and without any request, instigation, coercion, duress, fear, or hope of benefit or reward, or other action on the part of the police, then you would be authorized to consider it, provided you find from the evidence and the court's instructions that any such conversation or statement was otherwise freely and voluntarily given by the defendant. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said, and that he knowingly gave up such rights, then you may consider the statement as evidence. And if so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up those rights, then you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant and offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by evidence beyond a reasonable doubt that the crimes alleged have been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of this defendant beyond a reasonable doubt. During the trial, you viewed and heard audio and video recordings of interviews purportedly between the defendant and the police. You saw and heard the interviewing officers make certain statements to the defendant. You are instructed again that the declarations or statements of the officers are not evidence, and you should not consider such as evidence unless such statements are proven to you by other competent evidence. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witnesses offered for this purpose. You should consider all of the factors previously charged you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are as follows: the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove, beyond a reasonable doubt, the identity of this defendant as the person who committed the crimes alleged in the indictment. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are credibility and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but simply means the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that The acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Knowledge on the part of this defendant that the crimes of felony murder, aggravated assault, voluntary manslaughter, possession of firearm during commission of a felony, theft by taking, and concealing death of another were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit this defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of felony murder, aggravated assault, voluntary manslaughter, possession of firearm during commission of felony, theft by taking, and concealing death of another were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Gwinnett County, Georgia, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. I will now define the offenses. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. Aggravated assault is a felony, which I will define for you shortly. The state does not have to show that the defendant acted with malice to prove felony murder. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For voluntary manslaughter, the evidence must prove that the defendant caused the death of another person under circumstances that would otherwise be murder, and acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved that the injury was itself the cause of death, directly and significantly contributed to the cause of death, or significantly sped up the death, even though the death would have eventually occurred. Aggravated assault. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person while committing a felony, which is a crime against or involving another person. Felony murder and aggravated assault are felonies which have already been defined for you. For purposes of this offense, a firearm includes any handgun. Theft by taking. A person commits the offense of theft by taking when that person unlawfully takes any property of another with the intention of depriving the other person of the property, regardless of the manner in which the property is taken. Deprive means to, without justification, withhold the property of another permanently or temporarily, or to dispose of the property so as to make it unlikely that the owner will recover it. Property of another includes property in which any person other than the accused has an interest. When value is an element of an offense, as in count 7 of the indictment, charging theft by taking of a vehicle, the value that must be proved by the state is fair market value of the vehicle at the time of the taking. Fair market value is defined as the price agreed upon by a seller who is willing to sell but not compelled to do so, and a buyer who is willing to buy but not compelled to do so. Value must be proven by the state beyond a reasonable doubt for the item alleged to have been taken in count 7 of the indictment, the vehicle. But value does not have to be proven by the state beyond a reasonable doubt for the item alleged to have been taken in count 6 of the indictment, the firearm. The value of the property alleged in count 7 of the indictment, the vehicle, is an additional element that must be proved by the state beyond a reasonable doubt. I charge you that the state must show that the value of the vehicle, which was the subject of the alleged theft in count 7, was $5,000 or more. The form of your verdict should also include your finding as to the value of the vehicle supported by the evidence beyond a reasonable doubt. Concealing the death of another. A person commits the offense of concealing the death of any other person when that person hinders the discovery of whether or not another person was lawfully killed. If, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did on or about July 27, 2021, commit the offense or offenses of felony murder, aggravated assault, voluntary manslaughter, possession of firearm during commission of felony, theft by taking, and concealing death of another, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of one or all of these offenses, or if you have any reasonable doubt as to the defendant's guilt on one or all of these offenses, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty of the offense or offenses for which you do not believe the defendant is guilty. Let me take a moment to explain the verdict form. You're going to have a written verdict form with you. The verdict form is going to give you an option for each of the 8 counts of the indictment. For example, count 1 is listed as felony murder, and you will have 2 options. You will choose one option for each count, but you must render a verdict on all 8 counts. So for count 1, you will either check, we, the jury, find the defendant guilty of felony murder, or you will check, we, the jury, find the defendant not guilty of felony murder. So you will indicate your verdict form for each of the 8 counts. The only thing that is slightly different that gives you more than 2 options is count 7, which is the theft by taking of the vehicle, where you also have to encompass a verdict as to the value of the vehicle. So on count 7, theft by taking of the vehicle, your choices are guilty of the vehicle of a value of $5,000 or more, or guilty of the vehicle of a value between $1,501 but less than $5,000, or guilty of the value of the vehicle less than $1,500, or not guilty. So on the theft by taking of the vehicle, you have to render a verdict of guilty or not guilty that also encompasses what you believe to be the value of the vehicle based on the evidence. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of this defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. You are also to only concern yourself with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to act as the foreperson. The foreperson will manage your deliberations and will sign the verdict form to which all 12 of you must freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about the case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is as to each of the 8 counts, it must be unanimous on each count, that is, agreed to by all. The verdict must be in writing and signed by your foreperson, dated and returned to be published here in open court. A few more things. You will have, when you begin your deliberations, a copy of the indictment, a copy of the verdict form. You will each have a copy of the instructions on the law that I have given to you, and you will have the relevant evidence that has been admitted and that is permitted to go back with you in the jury room. When you get back to the jury room, you are to select your foreperson, but do not begin any deliberations until you have received all of these items that I've indicated that will come back with you in the deliberation room. 14 of you were selected because many things happen, and we still may have a need for all of you in some capacity, but the first 12 jurors that were selected will be the 12 jurors that will begin deliberating on this case. The last 2 jurors that were selected are our alternate jurors who will remain with us but be kept separate from the first 12 jurors unless one of the 12 jurors is disqualified for any reason, and then you will need to join in the deliberations. So our first alternate is juror number 34, Mr. Reed, and juror number 43, Mr. Perry. So I'll ask the bailiffs to keep juror 34, Reed, and juror 43, Perry, separate from the first 12 jurors. But please remember the alternate jurors during any breaks. If there are any questions that you want to ask the court about any legal concepts, or you need to see evidence that perhaps is not with you in the jury room, then that will need to be a note that is written by the foreperson and presented to the bailiff for any questions to the court. You don't have to ask me if you need to take breaks, but you will need to let us know, excuse me, you will let us know at some point if you want to cease deliberations for the day and continue into tomorrow. We are on your schedule, so at this point, you will determine your breaks and how long you deliberate until we reach a verdict. All right, I'll ask that you take all of your notepads and pens as well as your personal belongings and follow the bailiffs. All right, any exceptions to the court's charge from the state?
No, Your Honor.
From the defense?
No, thank you, Judge.
All right, I'll need you all to agree on what exhibits will go back with the jury and to place what goes back on the record and what does not go back on the record. we're ready to place what goes back and what does not go back on the record.
I think the simpler way to do it would be to just place what does not go back.
Okay.
Stacy's Exhibit 15 is a thumb drive, though technically, it could go back with no means to play it, we're gonna withhold it. I think that's by agreement.
Yes.
Stacy's Exhibit 58, 57, 56, 55, 43, 42, and 41 do not go back with the jury.
All right, if you will hand those exhibits to the court reporter, she will maintain possession of those exhibits. And you agree that all exhibit numbers that were not just referenced on the record will go back with the jury?
Yes, Your Honor. Yes.
All right, and then I will hand you as well the indictment where issue was joined and the verdict form. And if you will, one of you will grab the 12 copies of the requested charge that have been set aside for the bailiff. We can put everything in one pile. All right, that is everything that will go back for the jury. I will ask the attorneys for each side to leave your best form of contact with, write it on a piece of paper and leave it with the deputies or the court reporter so that they can share it with the bailiffs.
Bailiff took our numbers already.
All right, and so then we will be in recess until we have a question, a verdict, or they indicate that they want to recess for the evening.
Thank you, Your Honor.
All right, everyone needs to sit close by. I will only wait a short, reasonable amount of time to address any questions or verdicts. So, in the courthouse, in other words.
I got you, Judge.
All right.
I'm just trying to think of what the alternative is. You tase us. I'm gonna be here. I'm not going anywhere.
All right, and Mr. Lawrence Lewis. Please. Did you didn't bring your laptop in?
I can go ahead and get it.
We'll see where we land. Oh, not yet.
Okay.
Is he bringing Mr. Ford out?
I don't think you gave anybody that.
Did.
Oh, did you? I didn't hear
I
you.
thought it went to,
Yeah, I just heard.
okay.
I missed that, Judge, sorry.
All right, let's go back on the record. We have a question from the jury. It is marked as Court's Exhibit 6. It is dated April 27th, 2023. Dear Judge Fluker, the jury would like to see the prop gun used by the prosecution during closing arguments. Thank you. Elizabeth McKenna, number 31, jury foreperson. Will you show it to both sides, please? Mr. Umberg. All right, give me just a second. All right, proposed response or reaction from the state first. I mean, it's
It wasn't introduced in evidence, it was a
demonstrative aid.
used during closing. I don't know that it would be appropriate to send it back with them.
Reaction, response.
I think that's the only legal response. I don't even know if I would call it demonstrative evidence. It was an aid used during closing, which is not evidence. So I don't think that they get to see it again or touch it, or I don't think it goes back with them to closing. I don't know exactly how you're going to say that though.
I mean, I guess I can call it a prop that was used in
That's
closing argument that was not part of the admitted evidence.
That's fine, Judge.
That's fine with me.
All right, let me formulate that exactly and read it back. Give me just a moment. All right, our proposed written response is, we are unable to provide you with the prop gun as it was solely used during the state's closing argument and was not admitted into evidence by the court. Any exceptions from the state?
No, Your Honor.
From the defense?
No, thank you, Judge.
All right, I'll have Mr. Umberg show the court's response to the jury and returns Court's Exhibit 6 to the court reporter. All right, we'll just remain here momentarily until Mr. Umberg brings that back to make sure there's not any follow-up questions. stepping out and just making sure Mr. Umberg knows that I wanted him to come back to make sure there was no follow-up.
Sorry, Judge, for the delay. They're formulating another question. I thought we could just get it back.
All right, we'll just be at ease then and wait for the follow-up question. I'll hold on to this. Thank you.
And for your information, they're saying that they want to go to 4:45.
Okay. All right, so we will wait. Apparently, there is either a follow-up question or a different question, and we are being advised that the jurors want to deliberate until about 4:45 today if they do not have a verdict before that time. until we have them. Forward back out, please. Is this the only one we're expecting?
Yeah, they might get some more tomorrow.
Okay. Right, let us go back on the record. I have received a subsequent note from the jury that I have marked as Court's Exhibit Number 7. It is dated April 27th, 2023, and reads as follows. Dear Judge Fluker, the jury would like the measurements of Sig Sauer 365. Thank you, Elizabeth McKenna, number 31, foreperson. Right, so obviously I don't think there was any evidence about the measurements of the purported firearm. Does the state have a suggested response?
I think the only response is that
Those are not in evidence.
Similar to the last, no judge.
All right, let me propose a response. Give me a moment. All right, my proposed response reads as follows. Your verdict must be based on the testimony and admitted evidence, documents, photographs, etc. You must recall the evidence. I am unable to supplement any additional requested evidence after the evidence is closed by both sides. Any exceptions to the court's response from the state?
No, Your Honor.
From the defense? All right, I'll ask Mr. Umberg, the bailiff, to give courts 7 and the court's response to the jury. Are we anticipating an additional note, or are they just asking to be excused for the night at 4:45?
I think they're just asking to be excused for 4:45.
All right. Does either side want me to bring them back into the courtroom to remind them of their precautionary instructions, or let them be excused from the deliberation room at 4:45 for the evening?
I don't have a problem with the second option, Judge.
I don't either.
All right, so Mr. Umberg, they can be excused at 4:45 if they have no additional questions to report back tomorrow. They can let us know if they want to come back at 8:30 or 9. We're on their schedule, so they need to let us know what time they want to come back, and you can notify the attorneys. All right, thank you. All right, so I am going to step off the bench, and I am assuming at this point that we will be in recess until tomorrow morning, unless the jury comes back with an additional question before 4:45. The bailiff will let you know if they're going to resume their deliberations at 8:30 or 9. That's up to them. All right, so we will be in recess unless there is an additional question before 4:45. All right, and Mr. Ford can go back with the deputies.
Will you come back on at 4:45?
I do not intend to come back on the bench, so.
4:45, then I'll leave.
Correct.
Thank you, Judge.
Thank you. I will not come back on the bench unless there's a question. Number 6. I am going to wait until I get court's exhibit number 7 back, but you can be excused. I will wait just to make sure that I secure that court exhibit. Right. So you all will be in recess at 4:45. I will not take the bench again unless we have another question. Other than that, everyone is excused at 4:45. Do we know when they want to come back tomorrow?
9 o'clock, Your Honor.
All right, they will resume deliberations at 9 o'clock tomorrow. All right, everyone have a good
And
evening.
one more question.
Yes.
The evidence, do you want to leave it in the deliberation room or you want it back here?
Oh, yes, no, the state needs to take possession of the evidence overnight and return it to the bailiffs at 9 o'clock in the morning. So
We will collect it, bring it back.
everything, collect everything, and ensure that there is nothing written on the verdict form. If anything is written on the verdict form, please give it to me and not to the state.
Well, the jury began deliberating just about 2 hours ago. What the hell? You need a white?
No. I'm just marking the spot just in case you.
Okay. One, two, three, four. Hold on. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You're welcome. Bye-bye. Just about 15 minutes ago, the jury ended their deliberations for the night and will return in the morning. Now, they began about 2 hours ago. But they began around 3 o'clock. They began around 3 o'clock. Well, just about 3 hours ago, just about 15 minutes ago, the jury ended their deliberations for the night and will return in the morning. They began around 3. But earlier today, so before all of that, they heard conversations between the detective and the defendant on the board. And the defendant, Austin Ford. just about 15 minutes ago, the jurors wrapped up their deliberations for the night and they will return in the morning. They began, return in the morning. They began, and they so just about 15 minutes ago, the jurors wrapped up their deliberations and they will return in the morning. They began around 3 o'clock, but before all of that, they listened to recorded conversations between Texas and Austin Ford, recorded changing his story. Changing his story. Changing his story from not knowing what happened to Tori to saying he was at the park when she was killed. In close line. Trump's son focused on the shepherd. I remember all of this. Okay, that's right. Well, just about 15 minutes ago, the jury ended their deliberations for the night and will return in the morning. They began deliberating just about 3, but before all of that, they heard recorded conversations between the detective and Austin Ford, where he heard changing his story. And during closing argument, both sides focused on that check. Now, if I only remember that when I'm on camera. Hey, they're moving us to a noun B block. I'm gonna turn the mic off.
I heard that, but why?
I don't know.
Can we just shoot a look line and leave?
back to my script for today, right now. Don't screw myself up. Save this, get out of that. Drafts. Just 15 minutes ago, the jury ended just about 15 minutes ago, jurors ended their deliberations for the night and they will return in the morning. Well, just about 15 minutes ago. Okay, thank you. Well, just about 15 minutes ago, jurors ended their deliberation for the night and will return in the morning. They began around 3 o'clock, but before all of that, they listened to recorded conversations between detectives and defendant Austin Ford, where they heard Ford change his stories multiple times. And in closing arguments, both the defense Well, just about 15 minutes ago, the jury ended their deliberations for the night and will return in the morning. They began deliberating about 3 o'clock. But before all of that, they listened to recorded conversations. What is it supposed to say? They listened to recorded conversations between the detectives and Austin Ford. They listened to recorded conversations between the detectives and...
Is this yours?
I don't think so.
It's just a button, so I ain't.
It might be. Where'd you find it? Where'd you find it?
It was about a door.
Stand by. Maybe from yesterday. Stand by. Oh, just about 15 minutes ago. And you said this side, right?
Yes.
Well, just about 15 minutes ago, jurors entered their deliberation for the night and will return in the morning. They began around 3 o'clock. But before all of that, stand by. Well, Jennifer, just about 15 minutes ago, the jury ended their deliberations for the night and will return in the morning. And they began deliberating just about 3. But before all of that, they heard recorded conversations between the detectives and the defendant, Austin Ford, where you could hear Austin Ford shifting his stories about what happened to Tori that infamous night. And now both the defendant and the prosecution focused on that in their closing arguments. I don't know what she did, but she distracted me when I saw her come out, and I was like, dang it. It's okay. Three to 5. Again, just about 2 hours of deliberating. The jury ended for the night. They say they will return in the morning around 9 o'clock to continue those deliberations. Of course, we will be here and bring you all the updates. Live in Gwinnett, Bo Beth Yates, 11 Alive News. The jury headed home just over an hour ago, and before they began deliberating, they heard recorded conversations between the detective and Austin Ford, where he could be heard changing his story from not knowing where Tori Lang was to him saying he was at the park that infamous day when she was killed. In closing arguments, both sides focused on the shifts. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4. You're welcome. The jury began deliberating about 3 and continued until about 4. The jury began deliberating about 3 and continued until just before. Continued until. The jury began deliberating and continued just.
Did they say what we hit it?
No, they did on my check though.
You want to do your ins and outs now?
Yeah, I could do it. After about 2 hours deliberating, the jury ended for the night. After about 2 hours of deliberation, the jury ended for the night and said they'll be back in the morning. But before the deliberation started, they heard recorded conversations between the detectives and the defendant, Austin Ford, where he can be heard shifting his stories multiple times. And in closing arguments, they focused on that shift. No, I think I did it go one point. When you text me, I was at the bathroom.
I appreciate that.
About the food.
You can go ahead.
3, 2. Well, the jury, let me fix my hair. I think I got it.
Yeah, you do.
Ow.
Don't poke yourself in the eye.
3, 2. Well, the jury deliberated for just about 2 hours and then went home. They'll be 3, 2. Well, the jury deliberated for just about 2 hours before going home, and they will return in the morning. But before all of that, they heard recorded conversations between the detective and the defendant, Austin Ford, where he could be heard changing his stories, first saying he didn't know what happened to Tori, to then admitting he was in the park. And in opening arguments, both sides focused on that shift. All right, tag 3, 2. Jury 3, 2. Again, jury deliberations will begin 3, 2. Again, jury 3, 2. Jury deliberations will resume in the morning, and of course, 11 Alive will be there for 3, 2. Again, jury deliberations will begin tomorrow morning, and 11 Alive will be there. No, let's say we'll be there. 3, 2. Again, jury 3, 2. Again, jury deliberations will resume in the morning, and of course, we will be here for all of the updates. In Gwinnett, Boveth Yates, 11 Alive News. That's it. Always when I get it. Well, the jury headed home just about an hour ago before they began deliberating, and the jury headed home just about an hour ago, and before they began deliberating, they heard recorded conversations between the detectives and Austin Ford, where he'd be heard changing his story from knowing what happened to Tori Lang to saying, from not knowing what happened to Tori Lang to saying he was in the park the day she was killed. She was in the park when he was killed. And in opening arguments, both sides focused on the shift. The jury began deliberating about 3 and continued to just before 5. During the closing arguments, the prosecution, during closing arguments for the prosecution, the big focus was the multiple stories Austin Ford told detectives, saying he had no idea what happened to Tori, then later changing his story, saying that he was in Yellow River Park when she died in July of 2021. Previously, he was in Yellow. Tori. First saying he had no idea what happened to Tori, then later changing his story, saying he was changing his story, then later 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 changing his story, saying he was in Yellow River Park when he died in July 2021. Previously, the defendant argued Tori died from suicide after taking her mother's life, but the assistant DA demonstrated he believes that is virtually impossible.
Hey, Chrissy, is there another outfit that I can use for 53 keeps hanging up? Yes.
The jury began deliberating about 3 and continued to just before 4. During closing arguments, for the prosecution, the big focus was the multiple stories Austin Ford told detectives, saying he had no idea what happened to Tori, and later.
Okay, because it keeps hanging up for some reason.
But the defense painted a different picture, arguing Tori died by suicide after taking her mother's gun, but the assistant DA demonstrated why he believes that's virtually impossible. The jury began deliberating just about 3 and continued to just before 4. During closing arguments for the prosecution. During closing arguments for the prosecution, the big focus was on the multiple stories Austin Ford told to detectives. First, saying he had no idea what happened to Tori, and later changing his story, saying he was in Yellow River Park when she died in July of 2021. Was it July or June? I don't think it was July. Okay, thank you. Caroline, do you know if it was July or June she died? Well, the jury headed home just about an hour ago. $20 seconds.
She was found dead in 2021.
You know if it was July or June, you know? If you don't, I just want to keep with 2021 to be safe. Okay, thank you. Stand by. Well, Jennifer, the jury just went home about an hour ago, but before they start deliberating, what they did was hear recorded conversations between detectives and also that defendant, Austin Ford, where they could hear him changing his stories multiple times, saying first he didn't know what happened to Tori, then saying that he was in that park with her that day when she was shot. And during closing arguments, both sides focused on those discrepancies. Now, the jury began deliberating just about 3 and continued to right before 5. Now, during closing arguments for the prosecution, the big focus was the multiple stories Austin Ford told detectives, first saying he had no idea what happened to Tori, then later changing his story to saying he was in Yellow River Park when she died in 2021. But the defense painted a different picture, arguing Tori died by suicide after taking her mother's gun. But the assistant DA demonstrated that he believes that is virtually impossible. Take a listen. Again, jury deliberation ended for the night just about 5. They will return in the morning around 9 o'clock. And of course, we will be here for all the updates and sending it back to you guys in the studio.